Court officer? Court officer? Court officer? Please channel.
Records call for Agita. When?
ಮೊನ್ನೆ ಒಂದು ವಾರದಲ್ಲೇ ಬಂದ್ಬಿಟ್ಟು ಕಾಲ್ ರೆಕಾರ್ಡ್ ಮಾಡಿ ಸ್ಟೇ ಕೆಪ್ಟೆನ್ ಪ್ರೊಸೀಡಿಂಗ್
23 BK Manjunath.
1 week kind other side inquire ಮಾಡಿ.
Discuss matter next week for the request of arrangements for the appellant. This to secure TCR.
Number 39. Sorry, but next week any date, some personal inconvenience. I'm not able to do. Sorry. Any date.
39. For the request for the arrangement for the appellant next week.
From correspondence, because the will does not mention about any details with regard to these deposits. Therefore, I have made an application asking the respondent companies to furnish these details for us to.
Service is not complete against R2.
The service against R2.
You paid for R2? R2? R2 in petition is different and R2 in I number 3 is different. Then which R2 is to be served now?
Person who was managing the IA1.
Which R2 is to be served?
R2 in IA number 1.
You are not seeking any orders in, on IA number 1 of 2020.
Because I am seeking orders on IA number 1 also.
So then he has to be served. Yes. Learned advocate for the petitioner to pay the necessary process fee for service of notice against R2 in IA number 1 of 15. Yes, show the copy.
I don't want to. I will make sure.
Don't hide the copies.
It's done many times, but it's not enough. I have to acknowledge this, but it's not a big idea.
Looks time granted to do.
The statement of why did not office objection raised?
You are not pressing the 10.8A statement. Learned counsel for the petitioner submits that the statement of accounts filed on 10/8/2022 is not pressed, and fresh statement of account is filed on 14/11/2022. Where is it? Now, what was the office objection in the earlier statement?
They had said that it had to be notarized. So what we have done is we have converted it into an affidavit, and we under the affidavit, the course of the affidavit is the tabular format and notarize it.
Same figures.
Same figures, because there was no. In fact, the amounts have been limited to the account of the LRs of the deceased also. I have placed that on record along with the application for consolidation.
Yeah, transmitted the amount to the account, bank account. Whose bank account?
To their lawyer's bank account, Halal and Namazi. If my lords may take.
You could have. No, you could have enclosed the bank statement.
10/8/2022, the remittance particulars have been produced. I filed an application on 10/8/2022. That page number 5 is the Lord's case. By taking a lot to page number 5, it's the remittance particulars. Singaporean dollars lead. On 9th of February 2022 itself, it has been done.
9 February.
9th February. Have the combination of delay application.
Not found.
The application was allowed on the last occasion. We had filed it along with the inventory agreement.
Oh, yes. Annexure D, are you saying annexure D? Oh.
The loan application that I filed on 10/8/2020, seeking to condone the delay in filing my inventory.
Along with that, you find the.
Along with that, I
Continue. No, IA is already allowed.
Yes, he is allowed. Along with that IA itself, I had produced the remittance.
SBI, right?
How?
The Learned Counsel for the petitioner, the sentence I not questioning. Learned Counsel for the petitioner has also invited attention of this court to annexure A filed along with the application for condonation of delay in furnishing the account. Annexure A is the statement of account. This is whose account?
The account of their advocates in Singapore, Mallal and Namazi.
Statement of the account of the person who has received the amount. Covered by the villa, covered by the probate. Stop. This court is satisfied with the contents of the affidavit, which contains the statement of account. Statement of account furnished by the petitioner is accepted. Weeks time granted. 2 weeks time granted. Why so much of delay? 2016 matter.
Because the administration was issued on the 20.
I represent respondent 3 and 4 members. Case was posted today. That Lord, you have filed an affidavit Lord along with the additional document as the evidence for respondents. But they are objecting. Last time, my Lord, that should be converted as a suit in this regard.
The order is passed.
Not in past, my Lord.
Not to stand on technicalities. Application under order 821. That's I did it permitted to object while at the time of marking. That's the only request I'm.
Who is objecting?
He has every right there.
Because it's all unregistered document.
All right. That objection is always there. If the matter is evidence set for trial, all these contents you can.
But even if they admitted, because still he can question, argue on the
Petition is.
liability also.
Why Amicus Square is appointed in this?
That was at the time. The matter was-
Pleading complaints were not there.
The petition is filed seeking probate,
Probate.
seeking probate in respect of will alleged to have been executed by.
For in favor of the getting.
Executed by Committee, favor of Girish Kumar.
Petitioner hearing.
No, alleged to have been. Who is the testator? Who is the testator? Evidence agidella. Evidence is recorded.
Evidence agide. Namde evidence is.
before conversion.
It's not yet converted. It's
Why?
still showing as probate. Yes, sir.
It should have been converted. It should have been converted before recording evidence. So who is the testator? Who is the testator?
Kumara Avduta Swami.
Petition is filed seeking probate in respect of will alleged to have been executed by Sri Guru Kumara Avadhuta Swamiji, which is said to have been executed on 3/8/1989. The citation was published. The objection is filed by the impleading applicants.
Yes, yes.
Application allow ಆಗಿದೆಯಾ?
Allowed, yes.
The
It's allowed like consider order has been passed.
application is filed by the respondents to come on record to oppose to come on record and to contest the petition. Thereafter, they have disputed the execution of bill under the circumstances. In view of section 295 of the Indian Constitution Act, the petition has to be converted into testamentary suit. So, accordingly, the case is disposed of for statistical purposes. The petition is converted into testamentary suit. Adal pleading ಹಾಕಿದ್ದೀರಾ ನೀವೀಗ?
ಇಲ್ಲ ಆಗಿದೆ ಸ್ವಾಮಿ. ಅವ್ರ ಎವಿಡೆನ್ಸ್ ಆಗಿದೆ. From the stage of from this stage blood will continue.
It is also stated that even before this formal order, the parties have led the evidence. The petitioner has led the evidence in respect of his claim. Now the case is posted for cross-examination.
No, respondent evidence.
The
Respondent.
case is posted for the evidence of the respondent. Under the circumstances, for statistical purposes, this case is closed and the case is converted, case is closed and treated as testamentary suit. The central computer central project coordinator shall conclude the trial
From the stage of the respondent.
in the stage of evidence of respondent. IML ಅವರೇ ಆರ್ಡರ್ ಮಾಡ್ತಾರಲ್ಲ? Yes.
It has to be allowed.
It is submitted that applications are filed for production of documents by the contesting respondents. Contesting first respondent. For the reasons assigned in the affidavit, the application is allowed. However, it is made clear that the petitioner is permitted to raise all permissible objections at the time of tendering those documents in evidence. ಮತ್ತೆ additional respondent ಯಾರು ಹಾಕಿದ್ರು?
Right hand side. Let us see. 1 of 2017. That was allowed on 2017-2020. However, it's still showing as IA number 1 of 17. Or already they are on that one. Next is minutes 2 of 2017. That was also allowed on the same day.
ಅದು ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ ಇನ್ನು. What is listed is 2 of 18.
Yes, sir. They have not argued the matter. Next minutes, there is a detailed order passed on 27/2020. Says minutes based on that.
ಚೆಕ್ ಆಗಿದೆಯಾ? ಐ ನಂಬರ್ 2 of 18 ಏನಾಗಿದೆ? 2 of 18 ಏನಾಗಿದೆ?
Page number 18 of that order. Other pending applications. That is wrongly typed as 3 of 18. That is 2 of 18.
Where it is wrongly typed as?
2018. Case number 18 of that one. Last page. Argument.
Yeah, 17 ಆಗಬೇಕು.
2018. day of date in Bharat.
2 of 18, huh?
That is minutes, with the right hand.
This is stated by the learned for the petitioner that on 27/2/2020, this court has rejected I number 2 of 18. However, it is wrongly typed as I number 3 of 18 in the operative position in the said order. You would submit that I number 2 of 18 is does not survive for consideration, as it is already rejected. Where do you get the impression that the order passed is on I number 2 of 18? The first page, the order dated 27/2/2020. From the beginning, first line of the order dated 27/2/2020 would reveal that the court has 1 of 18 is there. Now, where do you get that the 2 of 18 was under consideration? No, when this order was passed on 27/2/2020, from the order, how do you say that what is adjudicated is I number 2 of 18?
The last page number 17, the last 3 lines.
That's
Application
no, that's 2 of 17.
2 of 17 and 1 of 18 are allowed.
That's all right. Now the note says 2 of 18 is pending.
2 of 18 is pending blood in the cast disclosure.
That's what I'm saying. Now, how do you say that 2 of 18 is disposed of?
Because minutes, there were only 3 applications. By mistake, 3 of 18 is the one. That's 2 of 18. Mr.
Little mistake is there. Where is the mistake? 1 of 18 antide. First line says.
1 of 18 is allowed.
So, all right. Now tell me, where is the consideration for 2 of 18? Password ಮಾಡ್ತೀನಿ go through and submit.
Very fast.
ಎಲ್ಲ correct note ಮಾಡಿ. There are so many notes. There are 12 notes.
I will assist.
I appear for the petitioner, my lord. I appear for the petitioner, my lord, in this. Humble apologies that 2,500 was not paid. I am arranging to make the payment today, my lord, to the.
25,000. Kodli says 25,000 cost.
2,500, my lord.
Kodli says 25,000.
2,000. It was by oversight. I'm arranging to make the payment today. My apologies, my lord. Need some time for
the petitioner submits it. Cost of rupees 2,500 will be paid today, alwa?
Yes, my lord. Yes, my lord.
You are paying it
will
today.
be paid today. Yes, I will be paying today, and I will file the.
Registry to verify and put up. Yes. Awesome.
I appear for the petitioner, my lord, in this case. 3 paper publications have been made.
The petitioner in this matter, my lord.
Serial number 8, my lord.
So what is the date of appearance?
Serial number 7.
Serial number 7, password.
Serial number 8, my lord.
Yes, what is the date of
Publication
date
was
of
on
appearance is 7. The date
My
of
lord,
appearance.
Yes. No, it was on 30th, my lord, but 25/6 was a paper publication. And subsequent to that, it has not been, it was called, but it was not, there was no time for the.
11/7.
Yes, my lord.
11/7.
There's no objection. There was
Yes,
no
it was
objections
11/7.
raised, my lord, for these paper
On
publications.
that day, matter was listed.
It was listed, but the court had no time to pass orders on the 3 paper publications.
Citation was published showing date of appearance as 11/7/2022. So on that day, the case was listed and appeared on your project. opposing the petitions between the probate either. Then I paid opposing the petition.
Letters of administration, my lord. Letters of administration.
This service of publication of citation is complete. Stop. Petitioner to need evidence before the central
My lord,
probate.
yes, my lord. Because the petitioners are the children and the grandchildren of the deceased.
Yes. Is it testamentary? They are claiming
No,
testamentary.
my lord. It's letters of administration for goods, my lord. Letters of administration.
Discuss matter next week.
Much obliged, my lord.
Ganesh,
The respondent.
Cost of the 5,000 acre, any amount deposit model clarification.
Suppose the
19 Myriad. Starter also said before the trial court. Is our yaar ಕೊಡ್ಬೇಕು ಅನ್ನೋದು.
Para 27 of the
why this cost was imposed
appeal dismissed.
to the respondent, successful respondent.
ಮಾಡ್ಕೊಂಡು ಆಮೇಲೆ
ಅವ್ರದ್ದೊಂದು receipt ತಗೊಬಿಡಿ, you have paid.
My own submission. This case matter. At the stage of admission, 25,000 arrears of maintenance was deposited before this. What is directed to withdraw the 25,000 to the respondent, permitted respondent to withdraw the amount. 5,000 rupees cost was imposed by dismissing the appeal. That 5,000 was not passed any order regarding whom it has paid.
Respondent ಗೆ
That was not paid.
ಕೊಡಿ ಅವರಿಗೆ.
But deposit amount also, the officer raised objection, if the amount was paid, the deposit amount was not permitted to withdraw.
See, the cost is, if it is not deposited, cost is not paid, you have to file execution ಅಷ್ಟೇ.
maintenance father ಇಲ್ಲ.
Understood.
Father ಇಲ್ಲ died, mother ಇಲ್ಲ died. Entire property possession ಅವರೇ ಇದ್ದಾರೆ, ಅವರ legal heirs ಅವರೇ ಇದ್ದಾರೆ.
If the cost is not paid, you have to file execution ಅಷ್ಟೇ.
ಕಾಸ್ಟ್ ಕೊಡಕ್ಕೆ ಯಾರು ಇಲ್ಲ, father ಇಲ್ಲ, mother ಇಲ್ಲ, both are died.
ಇದು ರಿಜಿಸ್ಟರ್ ನೀವು ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ದಲ್ಲ, ನೀವು ಕೇಳಿದ್ದಲ್ವಾ? You have to file execution.
Arrears of maintenance ಕೇಳಿದ್ ನಾವು.
ಆಗಲ್ಲ. Why this matter is listed at your instance? Why the matter is listed? Is it at your instance or what?
And the office objection was raised, or if 25,000 was not permitted to withdraw since the deposit cost was paid.
You want permission to withdraw this 25,000? This case was disposed of by the order dated 3rd July 2019. The page number 17 of the order would reveal that rupees 25,000 was already deposited by the appellant towards arrears of maintenance payable to respondent. Which respondent?
1 and 2, 1 to 3.
Respondents 1 to 3. Stop. There is no order for release of the said amount in favor of.
The order ಇದೆ sir.
ಇದೆಯಲ್ಲ ಮತ್ತೇನಾಗಿದೆ?
Order ಇದೆ. But ಈ amount deposit ಆಗ್ಲಿಲ್ಲ ಅಂತ ಅವರು ವಿತ್ಡ್ರಾಗೆ ಪರ್ಮಿಷನ್. ಆ ವಿತ್ಡ್ರಾ ಕೊಡ್ತಾ ಇಲ್ಲ, ನಾವು ವೋಚರ್ ಹಾಕಿದೀವಿ.
ಯಾವ ಅಮೌಂಟ್ ಡೆಪಾಸಿಟ್ ಆಗಿಲ್ಲ ಅಂತ?
ಅಲ್ಲ, ಈ 5,000 ಕಾಸ್ಟ್ ಡೆಪಾಸಿಟ್ ಆಗಿಲ್ಲ.
5,000 ಕಾಸ್ಟ್ ಇಲ್ಲ ಅಲ್ಲ, ಎಲ್ಲೂ ಇಲ್ಲ.
Para 27. Para 27. Madam, judgment.
If the cost is not deposited, then there has to be petition for execution. Your party is ready to pay the cost?
Father ಇಲ್ಲ, mother ಇಲ್ಲ, both are died. Only ಎಲ್ಲ ಅವರೇ ಇವಾಗ. Entire property ಎಲ್ಲ ಅವರೇ.
ಕಾಸ್ಟ್ ಕೊಡೋದಿಲ್ಲ ಅಂತೀರಾ ನೀವು?
ಅಲ್ಲ, ಯಾರು ಕೊಡೋರು ಇಲ್ಲ. Father ಇಲ್ಲ, mother both are died.
ಪಾಸ್ವರ್ಡ್ ರಿಜಿಸ್ಟರ್ ಕೇಳ್ತೀನಿ. ವಾಟ್ ಇಸ್ ದ ಇಶ್ಯೂ? ರಿಜಿಸ್ಟರ್ ಪಾಸ್ವರ್ಡ್ ರಿಜಿಸ್ಟರ್ ಕರೆಸ್ತೀನಿ. If the cost is not paid, the remedy is to file execution.
ಅಲ್ಲ, ನಮ್ಮ ಗಟ್ಟಿ 25,000 ಆರ್ಡರ್ ಇದೆ, ಅದಕ್ಕಾದ್ರೂ ಕೊಡ್ತಾ ಇಲ್ಲ.
ಐದು ಕೊಡ್ತೀವಿ.
ಕರೆಸ್ತೀನಿ ನಾವು, ರಿಜಿಸ್ಟರ್ ಕರೆಸ್ತೀನಿ. They should have paid that amount by this time.
but time. That's the problem. But 10.
The request of Learned Counsel for the appellant, each time granted to take necessary steps. Each time granted. Who died?
Respond number 1 minute. 309 of 10.
Memo is filed reporting death of respond number 1 in RSA 309 of 2010. Appellant to take necessary steps. Possible.
Thereafter, steps are being taken out, but our 1B has been served a lot, and ACD has been not. They are not, R1, we have been served, and there is no representation for R1. And again, we sought for a time, take a press notice about it. Thereafter, on conditional order 26, conditional order was passed.
You want to take steps against ACD? A1 of 17 is filed to recall the order dated 26/2016, dismissing the appeal against proposed respond number 1ACD. Stop. Stop. For the reasons assigned, the I number 1 of 17 is allowed. Order dated 26/2016 recalled. Appellant to pay necessary process fee for issuance of notice against R1, A, C, D, and E. There are 4 persons to pay the process.
Steps thrice, my lord, regarding unserved respondent on respondent 12, 13C, 14, and 15A. They permit me to file the necessary.
Learned advocate for the appellant submits that he would file application for service of notice through paper publication. 2 weeks time grant.
For submission. But the appellant has also died. Kindly permit me to take LRs of appellant.
Application is ready.
Ready.
File the application. File the application.
Whereas the amendment of the cost is concerned, the paper copy today is present.
Therefore, appellant.
I'm the appellant.
Please furnished.
And so whereas 2 IAs, those IAs with the urgency to make an order of injunction cause, the suit for partition, divergent fine. And I am entitled for option in the properties. For the humble transport granted the decree in my favor. And the humble appellant second appeal.
Appeal is admitted.
That it was admitted in the year.
Wait again. Who filed suit against whom?
It is on 10/10/2012, which was.
All right. Who filed suit against?
Suit against by this appellant. There is a plaintiff in the court below.
Against whom? Relationship.
Against his brother.
Brother filing a case against the brother. How the property was acquired by the brother?
It is ancestral property. I approved it with the document.
Inherited.
Yes.
Inherited from the father.
My father.
Why the suit is dismissed?
The other, the respondent has produced, it stands in his name in the recent past. Based on that thing, the appellate court has allowed them.
Yes, Mr. Appeal is already admitted. Why do you want to sell the property?
But not only selling. My lord, one third party is coming and causing interest, and against me they are giving complaints.
Well, I'm the respondent number 4, who is a subsequent purchaser. I've carved layouts in the property.
When you purchased?
2003.
When the suit was filed?
2000.
2000?
After I purchased, suit was filed without making me a party.
You're not a
I
party?
treated myself.
My lord, these persons are the developers are real estate agents. They entered into an agreement and they are.
No, if you had purchased prior to this suit, why is not made a party?
It's not prior to the suit. That they come up with the agreement and other thing only by filing the sympathetic application.
Just a second, when the property was purchased?
There was no registered deed also as on the date.
26/5/2003, madam.
26,
5/2000.
when the suit was filed? 11/6. So are you sure that the property was purchased or was there only an agreement for sale?
Because as far as my section is concerned, it is a sale deed, madam. It was purchased.
Have the copy of the sale deed?
So they, I'll address my argument. And so far as the IA which they are seeking, the IA,
You filed objection? You filed objection?
I find no objection.
Yes. What is your grievance? See, construction is going on.
There are enough construction.
Because there are 20 sites we have already sold to third parties and they're putting up.
All pendants, all during the pendency. The fact that you have sold the property is not a ground, all during the pendency of the appeal.
There's no.
You might have purchased prior to the filing of the suit, but all transactions which you have carried out are during the pendency of the suit. So there is not a defense for you to say that I have sold the property.
There was no stay whatsoever.
This pendency. You can't say that I have sold the property. You are bound by the judgment. But the case is pending if the property is sold. You are on the risk. I'm not finding fault with your act of selling the property, but you are bound by the judgment. So the fact that I have sold the property is not a ground.
Yes, my lord.
Because all those persons who have purchased the property have purchased the property in the pendency of this.
I'm bound by the final verdict of the Honorable Court, my lord.
So what is the extent of land? Huh? In how much area the construction is?
Interns, it is not the sites so as to decrease the entire property, high property. And each person to their whims and fancies, they are putting up constructions, marking out their sites. It's a land, agriculture land, not converted land. There's no such permission.
Scheduled property is 1 acre, 20 quintas. In fact, a similar application was filed in 2016, still pending consideration. And again, they filed IA1 of 22.
No, the construction is without permission, without conversion. How it is permissible?
No, it is without permission, my lord.
Where are the permission?
It's a date, I will get it and address my argument. Next week, any date.
And the Monday it will be fixed and let them
Learned counsel for the appellant submits that the construction activity is going on in the suit property without there being proper conversion order and permission to construct the building in the suit property, which according to the appellant is an agricultural land. Alva? Yes. He further submits that his suit for partition was paid by the trial court and same was set aside by the appellate court and he is in second appeal and the appeal is already admitted. Learned counsel for the respondent submits that the property in question was purchased by the respondent number 4. Number 4. Respondent number 4 prior to the filing of the suit itself. And learned counsel for the fourth respondent would also submit that the property is already converted. The property is already converted for non-agricultural use and necessary permissions have been obtained for construction. And seeks short accommodation to produce the documents in support of his contention. Is this matter on Monday? Also. Right. I number 1 of 19 is 5, seeking dispensation of paper book. In this case, on the premise that in RSA 383 of 2011, the paper book is already filed. Accordingly, I number 1 of 2019 is allowed. What is the office objection? This matter for finding. This is matter for final hearing. 7:12, 7. For what?
Regarding
2 weeks time granted. Pass over. Each time granted to take necessary steps. Sorry?
Take steps
Ah.
second time. R15 to R19 or is it just R15 and R19? Because the service is regarding 154.
R1 find R19 for second time.
Huh? Right, you're right. 1 week.
2 weeks time granted to take.
Empty the accounts of the fund. Also file an application first, and application was of some registry. So that application for condemnation of the case.
Bernard Council for the petitioner submits that I number 1 of 2022 filed for condoning the delay filing furnishing the accounts is not pressed as the registry has taken a view that the accounts are submitted in time. Accordingly, I number 1 of 20 dismissed as not pressed. Accounts.
Empty the accounts.
Can objection ilva?
No objection.
It is filed along with the affidavit. The petitioner has furnished the inventory of the properties covered under the villa.
Yes.
Will. Covered under the letters of administration. The accounts are submitted on a oath. Stop. This court has perused the accounts. Prima facie, accounts appear to be correct. Accounts and list of inventory appear to be correct. Accounts get a list of inventory matra ide. Accounts sell it. So inventory is on property, immovable property.
Also say that one immovable property.
Huh? Where is the 97 lakhs of the another?
Value of the property.
Value of the immovable property.
Value of the immovable property.
The account sell it.
Accounts are retained. Same value. Allows of retained.
Other than this, there are no movable property.
No other.
List of inventory and valuations furnished by the petitioner is accepted.
They responded.
Yes, we have objection for
No objection.
Bernard Council for the respondent has no objection to allow I number 1 of 2022 filed by the appellant seeking early hearing. Hence, I number 1 of 2022 is allowed. This matter for final hearing on 7th December.
Please.
hearing. Then application.
You filed application. Just Nakidar ಅವರು. Bernard Council for the respondent has filed I number 1 of 2022 seeking early hearing. Objection is not filed to the said application. Since the appeal is of the year 2007, I number 1 of 2022 is allowed, and this matter on 12th December for final hearing. ಒಳಗಡೆ ಬಂದಿದೆ. File application.
January.
4th January, same order. Filed by appellant. Respondent has no. What happened? Where? Appellant tabaka. So appears for the respondent. In time, application in time, delayed. Who are intending to come on record? I pencil. Appellant and delay control, appointment set aside. Objections are not filed and respondents are not filed objection. You have to amend the cost set and furnish the amended cost set. Notice issued. Ogilva. Issue notice on I number
26. I am for the applicant.
Issue notice.
Yes. To the proposed laws of respond number 1.
Yes.
And also I will take steps to R2.
Pay the process. Stay agidya. Stay agidya. No, they have filed application for vacating.
16 will not there. It states I number 16.
Order is in force till today.
Yes, till next date of hearing and that last time.
I number 1 of 16 is filed for vacating the interim order. Then appears for the respondent. Then advocate for the appellant submits that the order may be extended till next date of hearing. Interim order stands extended till next date of hearing. Steps to Abaka. You have to take steps. Weeks time granted. 2 weeks time granted to take necessary steps to remove the office objections.
I filed a memo minor reporting detail. Also furnish the details of the steps are not detailed.
When you filed memo?
I have filed a memo on 28th of October 2000.
When he died?
Death of Arban Minor is on 10/9/2020.
What about this I number 1 of 13?
Filed an application saying that I am the legal representative of respondent number 2 who died my lord executing a deed in my favor. And hence those applications do not survive and hence my pleading application have to be allowed. But unfortunately,
No. Subject to proof of the gift deed. Always like that.
Parties are not.
Then appears for the appellant. This is matter after 2 weeks. Then appears for the appellant after 2 weeks. Filed by whom? Filed by whom? No. Who filed? Who filed earlier hearing application? I number 1 of Madam Nodi for example. I number 1 of early hearing application. Enter respondent. Appellant. Respondent. I number 1 of 2022 is filed by the respondent seeking early hearing. Learned counsel for the appellant has no objection to allow the application. I number 1 of 2022 is allowed. This matter on 12th January for final hearing.
I'm sorry, my lord. I am Sharma, serial number 29. I missed it or earlier number 29. This has to be posted for final hearing, my lord. At this stage, I don't think that injunction.
You are for appellant? You are for appellant?
I am for the appellant, my lord. I'm sorry, I could not get connected.
The appellant would submit that I
They
number 1.
posted along with the main.
I number 1 of 17 can be considered along with the main appeal. This matter for final hearing. Yes.
Some date conveyed to the court. December or January on the date. January date ಏನಾದ್ರು ಕೊಟ್ರೆ
13 January.
13th January. Or earlier to that, about 4th, 5th, like that.
8 January.
8 January. Very well, madam. Sorry, I disturbed your lordship.
Sorry, 6 January. 6 January.
6th January. Very well, madam. I'm sorry, I disturbed your lordship in between.
Not at all.
ಲಾಭ ಬೇರಾಗಿ ಹೇಗ್ ಲಾಭ ಅಂತಂದ್ರೆ ಅವ್ರ ಕಂಟೆನ್ಷನ್ ನಾನು ಅಲ್ವೇ ಎಲ್ಲ ನಾನು ಸೈನ್ ಆಗಿ
No. What is no? What he says is he has not sold. Now, what he says is it has been granted to him. So the signatures, the opinion says that the signatures differ. Then yeah, no case. If they really
contention saying that he is not that person. My contention is not that.
No, you are saying that he is a grantee. All right. Awesome. Aida, plot number 8 and 9.
Vote in my favor, but vote that CD can't be declared as valid. Why? Only declare it as regards your share is not valid. Let court says instructions.
Also, with very nice. For 2 weeks. Pretty fine. Huh? Also,
First week of December, my lord.
awesome. Why? Need consist of the respondent seeks a short accommodation. This matter on 6th December. You are for? The request of appellant for the none appears for the appellant. The request of appellant for the respondent discuss matter after 10 days. Possible.
Declaration.
Expiry degree.
Event number 4 has filed suit. So decree, I filed appeal dismissed. The appeal matter, there is an observation that unless you seek declaration, the partition, declaration cannot be granted. I filed the matter suit for partition and separate possession. The suit for partition, my share has been declared separate.
Subsequently, you filed one more suit.
Yes, sir, partition suit. Because of the finding, the appellate court, unless you seek declare partition.
You want to withdraw this? Why? No, you filed a suit for declaration injunction.
Defend number 4,
Defendant number 4 filed a suit.
declaration and permanent injunction.
How defendant number 4 can file a suit?
He is explained on the ground that there was earlier Panchayat Parikar.
So D4 can, how he can file a suit?
But he has filed against me.
Defendant number 4.
Defendant number 4 has filed a suit. The respondent number 4. Sorry. Has filed a suit on the ground that there was earlier Panchayat Parikar. For decree. I filed appeal. In the appeal, it was specifically finding is unless you seek a partition, the property, so you will not succeed. Then I filed partition. 27 guntas is the joint family property. There is no dispute.
No, you filed appeal challenging the decree for partition.
Decree for declaration of title. That was
decreed.
It was filed on the ground that earlier there was a Panchayat Parikar.
The suit was decreed.
Decree.
You questioned it.
I questioned it.
Appeal was allowed.
Sir, appeal dismissed. Appeal dismissed. Against which second appeal is filed. And during the pendency of this appeal, I filed a partition.
Why?
Because the appellate court finding is earlier there was a Panchayat Parikar, and my contention is not binding on me, and proper shares had not been allotted. Therefore, I filed a separate partition suit itself. In the partition suit, the trial court has held that.
No, you filed a suit for partition based on the observation made by the first appellate court. First appellate court says the earlier partition is
not binding on me.
Not binding on you.
And your intention for off sharing 27 guntas. It's not disputed by the other side.
Now what happened to that partition suit is decreed.
Decreed, against which they have not filed.
When it was decreed. So produce that document.
Actually, comprehensive of time.
To file an application along with this. After all right, this document has come into existence after the disposal filing of this appeal, right? Could not have produced it earlier. To file a memo, to file it in the registry. Or barta rahega?
Government primary that is not in that at all in issue. The subsequent development.
22nd February, 1 ವರ್ಷ ಬಂತ. Donald Counsel for the appellant has produced a document along with the memo, produced the judgment and decree, OS number 16 of 2015 on the file of additional civil judge copy, along with the memo. Stop. The document is, the judgment is placed on record. Donald Counsel for the appellant would further submit that OS number 16 of 2015 is filed based on the observation made in RA number 86 of 2006.
RA number 16 of 2009.
86 ಅಂತಿದೆಲ್ಲ.
86 suit.
RA 86. RA number 86 of 2006 on the file of senior civil judge Mandur. Stop. Donald Counsel would submit that in view of judgment and decree passed in OS number 16 of 2015, wherein the present appellant is awarded share in the social properties This appeal has to be allowed. Stop. None appears for the respondent. List this matter tomorrow to hear the respondent. Monday. Are you copy kottidira? Alla you no, you serve the copy. File this. No, file it in the registry along with this acknowledgement. Otherwise, there will be objection. You file this document in the registry along with the acknowledgement. It's correct, but I have to record Allah. No, I observed that he is not present before the court. So let it be on record in the registry along with his signature. So with the file matter. Also. ಅಲ್ಲ ಅವ್ರು ಬರಲ್ಲ ಗೊತ್ತಾಗಲ್ಲ ಅವ್ರಿಗೆ.
42, Ramesh.
So appeal has to be allowed ಈಗ ಅಲ್ವಾ? ನಾಳೆ ಹಾಕೊಂಡಿದ್ದೀನಿ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಹಾಕೊಂಡು ಮಂಡೇ ಬರುತ್ತೆ.
Ramesh.
Yes. No, that is the law. Now, one difficulty is in Bunyamat's case, what has happened is para number 37, which you are lying upon, that says if the appeal is pending, still the review court can exercise the jurisdiction and proceed with the review petition and decide the matter on merit. But the ratio laid down in Bunyamat's case is called out in para number 47. Bunyamat's case. Judgments. And that ratio let's now come to para number 26.2 in Probate. This is larger bench. 26.2. Page 395. No, last. Once leave to appeal has been granted. That may not be SLP here, but the appellate jurisdiction of the appellate Supreme Court has been invoked. The order passed in appeal would attract the doctrine of merger and order of the next to para number last on an appeal having been preferred or a petition seeking leave to appeal having been converted into an appeal before the Supreme Court. The jurisdiction of the High Court to entertain a review petition is lost. So pendency is not the criteria. See, disposal is not the criteria. The pendency is also there. Then the jurisdiction is lost. What you are saying is there is no appeal against order passed in RSA, decree passed in RSA. That is your contention. The contention based on para number 37 in Bunyamat's case, that mere pendency will not take away the jurisdiction of the review court, is not available. That is the ratio. What you are trying to say is this is not an appeal against the decree in RSA. It is only an appeal against the order passed in writ petition. Show your attention. So that para number 37 is not available. Yes.
Are a petition seeking leave to appeal having been converted into an appeal?
Yes. Yes.
The restriction of the High Court to entertain a review petition is not thereafter as provided by sir.
This is the law. This is the law. Para number 37 is not the law. Para number 37 says.
The larger bench.
No. Para number 37. No. Even in Bunyamat's case, you refer to the Bunyamat's case. In Bunyamat's case, also the ratio is culled out. The last paragraph, para number 47, if I'm correct. So there also they say the same thing. Person. So other day your contention, the appeal is pending, and as long as the appeal is not disposed of, then the jurisdiction of the revenue court to entertain the review petition is still available. That was your contention. No, that is what is said in para number 37 of Williams, but not in para number 47. Not in para number 47. Sorry, 44. In para number 44, Kunyamas case, page 384. So ratio laid down is found in para number 44. Para number 37 is not the ratio. So para number 47 says 44. Sorry, 44. Roman paragraph number 7. No, forget that. Come to Roman 4, sir. Roman para 7. Next page. Last paragraph. So ratio is the appeal is pending, then the jurisdiction to entertain the review is lost. Para number 37 would give an impression mere pendence of an appeal is not a ground to say that the right to review is lost, right to seek review is lost. Disposal of appeal would also is the only criteria to say that whether the right to review is lost or not. That is the impression that you get in para number 37. But the ratio is called out. It is summed up. So this has been affirmed in larger bench, 3 judges bench. So now your only contention is appeal pending before the writ appeal court is not an appeal against the decree in RSA so and so. That is the only ground available to you. To say that the review petition is maintainable.
Which was filed earlier and all.
Yes. Para 37 clearly.
Or an appeal having been referred, or a petition seeking to leave appeal having been converted into an appeal. Nonetheless, as your worship is directly consider the point that our cases are. At the first of the petition, I would like to make two statements. I could not have filed just writ appeal at that point. Assuming for a while, I had filed a writ appeal because writ petition order was there. I did not have filed a writ appeal because the appeal court, there this RSA judgment will be hanging on. Similarly, assuming for a not have this. Okay.
No, what you are trying to say is inevitably you have to challenge all the orders. All the orders. That is understood. Yes. One theoretically speaking, one option was there to challenge all the orders in the review petition before this. Theoretically speaking, that option was there. Whether you make out a case for error apparent on the face of the record, there is a different story. But you could have challenged that order, all the three orders in review petition.
ಪಾಸ್ ಮಾಡಿದಾಗ ಎರಡನ್ನು ತಮಗೂ ಗೊತ್ತಿದೆ. ಎರಡು ಕೇಸನ್ನು ನಾವು ಒಟ್ಟಿಗೆ ತಂದಾಗ ಎರಡು ಕೇಸನ್ನ ನಾವು ಸಪರೇಟ್ ಆಗಿ ಎರಡು ನಂಬರ್ ಆಗ್ತದೆ.
Whatever. You could have challenged the order passed in writ petition by filing a review. Whether you succeed or not, that's a different story. Review petition would have been maintained. No, you have got two remedies. One is to prepare an appeal, and if it is permissible, to file a review. If the case falls under the Order 41 Rule 1 or whatever.
there had been a risk, then I could have challenged it or to the month directly. Now, the question here is that there is an error apparent on the record. There is a what? There is a,
So the contention, one contention which you raised, that as long as the appeal is pending, the power of the review court to hear the review petition on merit is not taken away. That is not available. Correct. Allah, you are justified in making that submission. There is no difficulty. The only question now is whether
the review petition of 7:20 does not happen. 10:32.
yes.
Date of filing is but there is review petition notice
Admission is not the criteria. Yes. Yes. Understood your point. All right. Now, see, one of your grounds is that these petitions could not have been, the argument was addressed simultaneously. There should have been separate orders. That is one of your contentions, right? One of your contentions. Yes, one of your contentions before this court. So what you are trying to say is, or there is an agreement, at least on this point, both of you are on the same page, that the reasons assigned for disposal of all the three cases is one and the same. All the three cases, 2 writ petitions and 1 RSA. Whatever, but the reasons assigned are same. Well, see, if you read the last 2 lines in the judgment, which is under review, for the reasons discussed supra, writ petitions are disposed of. That's how it says. So according to the judge, forget about according to the court, reasons are one and the Understood. See, now what happens is, now let us come to the practical aspect of this matter. Except now prima facie, in the sense, learned advocate for respondent is also conceding the point that there are errors apparent on the face of the record. Yes. There is no doubt about it. Now let us get into the practicality of this, assuming that I allow the review petition on the ground that the error is apparent.
Last point is between the
Which is the last point? I'll come to it. I will allow the review petition. The consequence is judgment in RSA is set aside, right? But that order clubbing all the 3 cases, that remains. That order remains. I cannot proceed further. Because the order is there clubbing all the 3 cases. And against 2 judgments, now there are 1 writ appeal is pending, not against 2 judgments, against 1 judgment. 1 writ appeal is pending. Then how to proceed further? This is one aspect. Another aspect is, there is 1 more writ petition, order is passed, assigning the same reasons, and that is not under challenge. That remains. No, that remains. That reasons assigned would remain. So, this order is, reasons are taken away. Reasons for disposal of RSA are taken away or set aside. Same reasons for disposal of one more writ petition that is there, that is not under challenge. And there is one more writ appeal. Now, if you apply the ratio laid down in Kunyamat's case and this Code Distillery's case, if you are trying to say that I have not preferred any appeal, so the review petition is maintainable, then that writ appeal doesn't become infructuous, because what you are trying to suggest is the grounds are different, reasons are different. Just a second. No, assuming that the writ appeal court dismisses the appeal, then the very judgment which I have set aside in review jurisdiction, that is confirmed there. That gets confirmed. No, there is a possibility. No, according to accepting your contention, accepting your contention, the writ appeal court cannot say that it has become infructuous, because according to you, the judgment in RSA is questioned in this review petition. What is questioned there is a different order.
Well, just. The review petition is and the chances are that we do not know. Chances are that the interpretation court would remit the matter back to the recipient and publish constitution. This is not all. And then we have to again seek for the order of the that this is something.
Clubbing order remains. None has questioned. No, what about the order in another writ petition which is not under challenge? That remains on paper. It remains. So when you are
There are no issues at all.
so when you see, madam, that is the difficulty. Madam, that is the difficulty. Just a second. That is the difficulty. All the three cases are clubbed on the premise that the facts are similar, property is similar, and judgment in one case will have bearing on another case. That is the understanding, right? See, what is the reason for clubbing the cases? What is the so identity may be different, but both the parties are claiming under the dispute of same property. Understood, sir. The property is same, alma. Then why it was clubbed? See, exactly, it may not be same. If you are saying that the properties are overlapping, then if it is portion of the property is overlapping, then it if it is overlap ಅಂತ ಹೇಳ್ತಾ ಇದ್ರೆ ಮತ್ತೆ ಬೇರೆ ಬೇರೆ ಪ್ರಾಪರ್ಟಿ ಅಂತೀರಾ? Correct. See, if one case is decided in one way, that will have bearing on another case. In another case, that is the reason why all the three cases have been clubbed. See, whatever reasons are same, reasons found in RSA, which is under review. It is a
Decided to validate the remains as it is. Doesn't show whether the order is existed or not.
Then it was a very good case for review in that case also.
The preamble of the the audience. The order along with the
what remedy a person has provided because the court state now provides for different remedies. Simultaneous remedies are also available in certain cases. Now, if your lordship were to read this code and this now there is 37 pending with the one code over there. You just see ultimately can they go to 380?
$382, no? Yes.
OS was dismissed. Thereafter, RFA was allowed. OS was dismissed. It's accepted. RFA was dismissed. Delay control special infections. And RFA is still reviewable. Right? Dismiss RFA High Court reviewable. Review was allowed. That was challenged. Then the court said it is permissible. The SLP delay control special infections. So SLP nalli on merits are this is the facts and circumstances. Now your lordship is given case of fact. Para 8 alone madukondare. Para 8 alli 384 alli page 384 para 8 alli. The question of law which needs to be determined with the opposite circumstances is as to whether the review petition is given before the High Court, seeking review of the judgment against which the special petition has already. This was answered, and the court said if it is not an order on merit, but nevertheless, orbital dicta, whatever it is all laid out for they are all known by this paragraph. 396, the last paragraph.
Even Punyamat says, Punyamat para number 44, they have summed up the ratio. That is affirmed.
Also, if that is deciphered, then I stand one side. If it is decided the other way, I stand. That's all I'm satisfied.
Now, if you look into the Order 47, Subrule 2, multi-party cases. So what? The only if you read the entire Order 47, rule 1 and 2. The impression one would get is the window for filing a review petition, despite there being an appeal, is available only to a person who has not filed appeal. There's one aspect. No, I'll understand one aspect. And even on a limited ground, to say that the grounds urged in the appeal and the grounds sought to be urged in the review petition should be different. If they are again alike, then it is not permissible. No, that is relating to the second part. I'm only concentrating on the first part. First part says the right to file review petition is available, provided the grounds urged in the review petition and grounds in the appeal are different. If they are identical, it is not permissible. That's what it says. So the small window of opportunity given to the party who has not filed an appeal before the appellate court and to file a review petition is only a small window where he can urge the grounds which are not urged in the appeal by the other party. So when that is the case, the underlying principle is a person should not be allowed to file an appeal before one court on certain grounds and review petition on certain grounds if the party is one and the same. Now, if your contention is to be accepted, just let me complete. Please accept it. What you're trying to suggest is if two sets of grounds are available. Let us say there is only one party in a proceeding where is agreed by the judgment. He can file appeal on ground number 1 to 6, and from ground number 8 to 10 he can come to review court. That is not the underlying principle. That is to be avoided. The reason is there is a possibility of conflicting judgment. Review court may take one view, the appellate court may take another view. That is the underlying philosophy of not allowing an appeal as well as the review petition by the same party. That is the underlying logic.
I cannot urge the grounds that I have urged for grounds as grounds for review. Review is something which you are not sure to catch.
No, grounds urged in review petition can nevertheless be urged in the appeal also. There is no difficulty. No, there is no bar. Appeal you can urge all grounds. There is no restriction. Review grounds are restricted.
I had not filed a appeal on that. I had only filed a appeal. Where I had challenged, honestly, also subscription.
That cannot be permissible because not permissible. So you are not prevented from approaching Supreme Court. You are not prevented in this case either from questioning the orders passed in review petition on the ground that it suffers from error apparent on the face of it. That was also there.
That's because I have. Now the question is that.
There is, the subtle question is what you are trying to say is law says if an appeal is not filed and the order is appealable, I can maintain a review petition. That's what you are trying to say. Yes. That's what you are trying to say. The only difficulty is the order is a common order and the reasons cannot be segregated. If I just allow the review petition, say from day one, within 2 minutes, I'm submitting that this, I'm convinced that this case suffers from error apparent on the face of the record. So, not even for a second, I was in doubt to say that this case, the judgment suffers from error apparent of the record. There is no doubt about it. From day one, my anxiety was whether this review petition can be maintained. Yes. Fortunately for the petitioner, review petitioner, the learned counsel in his fairness submitted that this case suffers from some error apparent on the face of the record. But he tried to bring this case under Order 47, Rule 2, and says that appeal is filed, same judgment. The judgments are reasons are not different. The facts and the reasons are explicitly interwoven, something like that. So all along I have been submitting. If the writ appeal was withdrawn, I could have easily allowed this review petition 2 minutes. Unfortunately, the counsel for the petitioner, I'm not You are not instructed. If you are not instructed in this regard, I can't help. The counsel for the petitioner should have taken the clue.
That is good. I am seeking liberty to file an application for review before this honorable and then also reserving liberty to approach the honorable court if the review petition is dismissed. But there we have to cross check on that because if you have done it before filing the writ appeal, that's different. Have you done the writ appeal? Supposing review petition gets dismissed, then we can't go back to the writ appeal. That's a problem with it. That's also an equally important.
No, if the review petition is dismissed, you can file it. No difficult.
The permission is granted. The permission is granted. The liberty is granted. If it is not granted, we are out.
Sir, ಏನು ಹೇಳ್ತೀರಾ?
That's 20
That is my respectful submission. Appeal is filed, appeal is admitted. And because of sub-rule 2 of 47, this is not permissible. The remedy, what is the remedy? I not refer to this aspect. What will happen? They move the Supreme Court, notice to me another round of litigation on that. My lord, I don't have an instruction from my client. Therefore, I respectfully submit that Order 47 rule to consider it and review petition is liable to be dismissed. That's my.
Dictate the order. Now I've dictated the order.
I thought that cannot be.
He's not consenting for it.
Yes, on that.
Already oppose ಮಾಡ್ತಾ ಇದ್ದಾರೆ. Now it's too late.
File an application. But it has before we have been and that.
That will not change the color of this review.
No, the writ appeal is not there. There is no difficulty.
Yes.
What they are trying to say is they'll withdraw the writ appeal.
Once I appeal, the words used.
It is for them.
Agala.
They have filed an appeal. They can withdraw it. There is no difficulty.
They cannot insist on.
If you are saying that the court has already heard and part dictated the judgment, then I have to proceed.
I will not. But I will not concede to the fact that they have the right to do all that. That is a convenience of the.
An interesting point is raised. Let this matter go to Supreme Court. Let us see. If not for this case, let there be a law declared. So what I feel is, you made a very valid point in the sense, you are right to file appeal against the order passed in the petition that is there. You have got a right to file review if you feel that the judgment suffers from errors apparent on the face of the record. When two cases where the appeal lies to a different jurisdiction, different forum. That is there is a precise question which is involved in this case. If that is done, what is the consequence of filing appeal against one order before a different jurisdiction and not filing appeal against another order before a different jurisdiction and filing review? What will be the consequence? How the order 47 is to be interpreted? That is the precise question. So let there be a finding by the Supreme Court. Now, too late. Now, suggestion came from me. Should not look odd. The contention of the review petitioner is that judgment rendered in RSA 819 of 2013 is not called in question by availing the remedy of appeal before the apex court. It is further contended that what is questioned before the writ appeal court is only the order passed in writ petition number 10930 of 2012. Is there further case that order passed in the writ appeal filed by them, they are not sought for a judgment to set aside the judgment and decree in RSA 819 of 2013. On this premise, it is contended that the review petition challenging the judgment and decree in RSA 819 of 2013 is maintainable, as the case of the petitioner falls under Order 47, Rule 1A, which provides for review petition where the appeal is allowed and the appeal is not filed. The learned counsel for the respondent would submit that the order under review and order which is questioned before the appellate court by filing the writ appeal are one and the same order. Reasons are also one and the same, and the reasons and the both orders are so inextricably interwoven, it cannot be segregated to say that particular portion of the order is an order passed in RSA 819 of 2013, and the remaining portion of the order is the order passed in the petition number 109 of 10930 for the respondent the right to file review petition in a situation where the appeal is filed against an order is also governed by procedure. According to the learned counsel for the respondent, this right to file appeal as well as review against the same order recognized in Order 47 Rule 2 is available in a situation where the parties are different. This court has perused Order 47 Rule 1 as well as Rule 2. From reading of Order 47 Rule 2, it is apparent that the Order 47 Rule 2 is an exception to Order 47 Rule 1A, which says that an appeal is a review petition is not maintainable where the appeal remedy is availed by the party. However, it is to be noticed that Order 47 Rule 2 is available only in a situation where the party applying for the appeal and the party applying for the review are different. From reading of Order 47 Rule 2, it is also apparent that the party who seeks review of the order cannot seek review if the grounds of appeal and grounds of review are one and the same. The Order 47 Rule 2 is very clear that only if the grounds of appeal and grounds of review are different and the parties are different, then the review petition can be filed, notwithstanding the fact that another party has filed appeal against the said order. If you look into the underlying principle under Order 47 Rule 1A, which prohibits review petition in an event where the appeal is filed by the same party, it is explicitly clear that the intention is to avoid two conflicting judgment by the appellate court and the court reviewing the order. Keeping this object in mind, this court is of the view that the review petition by the party who has filed an appeal is not tenable. The question for consideration in this case is whether this review petition can be treated as a review petition only to seek review of the order in RSA 819 of 2013 or the review of the order passed in WP 10930 of 2012. Full stop. The ground search in the review petition will disclose that the petitioner is seeking only to review the orders passed in RSA 819 of 2013. Stop. There is no difficulty in accepting this contention. However, what is to be seen is in the order dated 23rd June 2021, which is under review, this court has discussed the contentions raised in the writ petitions as well and assigned reasons for disposing of all the three cases. And the last paragraph of the impugned order would read as under. The writ petition number 44146 of 2011 filed by Venkatama and the writ petition number 10930 of 2012 filed by Kumari Gowda are disposed of in accordance with the observations made above. Stop. The last phrase, inverted comma dalaki, in accordance with the observations made above, would make it clear that reasons for deciding RSA 819 of 2013 and the reasons for disposal of writ petition number 10930 of 2012 clubbed with writ petition number 44146 of 2011 are one and the same. Stop. If the review petition is allowed, except in the contention that RSA 819 of 2013 is the only order in RSA number 819 of 2013, judgment in RSA 819 of 2013 is the only judgment which is sought to be reviewed. Then, if they accept in the contention the review petition is allowed, the order passed in RSA 819 of 2013 will have to be set aside. However, the challenge to the writ petition, order passed in writ petition number 10930 of 2012 would remain. Except in the contention of the petitioner is to be accepted, said writ petition does not become infructuous. It would become infructuous only in a situation where the order under review and order which is challenged in appeal are one and the same. Under the circumstances, this court is of the view that, except in the contention of the review petitioner, that no appeal is filed against the order passed in 10930 of 2012, though technically appears to be correct, but in substance is not correct. Lala, see, what do you mean? So, sorry, sir. Order passed in RSA 819 of 2013, though technically appears to be correct, what is to be seen is what can't be lost sight of the fact, lost sight of is that the same order is called in question by filing writ appeal number so and so. Under the circumstance, this court is of the view that if the contention of the review petitioner is to be accepted, then it is as good as saying that the review petitioner can file an appeal against an order on certain grounds, and on raising different grounds, he can be permitted to file a review petition. Such a situation is not contemplated under Order 41, Rule 1 of Code of Civil Procedure. Next para. The learned counsel for the petitioner, senior counsel for the petitioner, has also relied upon the judgment of the apex court in Punia Ahmed versus the state of Kerala, first case of state of Kerala reported in so and so, wherein in paragraph number 36, the Honorable Apex Court has held that the review petition is maintainable despite the appeal being filed against the same order, as long as the appeal is not decided on merit. ಅಲ್ಲ ಹಾಕಿದ್ದೀನಿ ಬಂದಿದ್ದೀನಿ ಇದು ಬರೆಯೋದು ಬೇಡವಾ ಬೇಡ. The learned counsel for the senior counsel for the appellant and respondent have also referred to the judgment of the Honorable Apex Court in the case of Probate Distilleries versus Madheshwara Sahakara Sakkare Karkhane 2019 4 SCC 376, wherein the ratio laid down by the Apex Court in the case of Punia Ahmed is upheld by the 3 judges bench, where the court says, where the Apex Court says that once the appeal is filed against the order, then the right to file review petition is lost. Since this court is of the view that the order under review and order which is called in question in writ appeal are one and the same in substance, the contention that the review is sought only in respect of judgment and decree in RSA 819 of 2013 cannot be accepted. Since this court is of the view that the writ petition is not maintainable, the writ petition is not review petition is not maintainable, the contentions raised on the merits of the matter are not considered. Accordingly, the writ petition is yes. Paragraph Learned Counsel, Senior Counsel for the appellant has also produced the copy of the appeal memo, filed appeal memo pertaining to the writ appeal, which is pending before the appellate court. Full stop. This court has produced the grounds urged in the said appeal memo, and also they considered the prayer made in the said appeal memo. The writ appeal would clearly disclose that the fact that the appeal is filed only against order passed in writ petition number 10930 of 2012. There is no prayer to set aside the judgment and decree in RSA number 819 of 2013. Stop. There is no difficulty in accepting the contention based on the form of the writ appeal, but in substance, the order being one and the same, this court is of the view that the review petition is not one. Yes. It is also ಅದನ್ನ ಒಂದ್ ಕಡೆ ಬಂದಿದೆ ನಾನು ಹೇಳ್ತೇನೆ ನಿಮಗೆ ಅದನ್ನ ಹಾಕಿದ್ದೀನಿ ನಾನು writ petition is admitted, writ appeal is admitted, consideration of interim prayer is deferred ಅಂತ ಬಂದಿದೆ ಅವತ್ತೇ ಬಂದಿದೆ. But nevertheless very interesting case.
But yeah, both of us.
So ultimately there is no adjudication on merit. So nobody is losing anything here. ಏನಾಯ್ತು? Twenty-one. 14. Third Sri Uma Shankar, learned counsel appearing for the appellant, and Sri B. Ramesh, learned counsel appearing for the respondent. So, in this regular second appeal, the appellant is questioning the concurrent finding of the trial court in OS number 89 of 1999 on the file of civil judge Ruby, and judgment and decree rendered in RA number 10 of 2009 on the file of senior civil judge right function before the trial court to be decreed, holding between the plaintiff and question by the defendants by filing the aforementioned appeal. The appellate court has dismissed the appeal, but has given a finding that the previous partition is not established. Antana, but they are dismissed at the appeal. The declaration and confirm it. Declaration and confirm it. No, that was by the trial court. The first of no, but how the declaration of title is granted by the appellate court? The appellate court is of the view that the partition has not taken place.
Partition is not binding on the plaintiff.
Party alva. New party alva. Plaintiff is defendant is not a party. Alva. The first appellate court though has come to the conclusion that the defendants are not parties to the previous partition set up by the plaintiff, has dismissed the appeal with a liberty to the with an observation that the defendant can file a suit for partition. Challenging the said judgment and decree, the defendants are in this regular second appeal. Learned counsel Sri Uma Shankar appearing for the appellant filed a memo along with the judgment document, which is the judgment and decree hakilva judgment aste judgment dated 22/2/2022 OS number 16 of 2015 on the file of additional civil judge at UP. This court has produced the such judgment. This is a judgment rendered in a suit filed by the present appellants, and the suit is apparently based on the observations made in RA number 10 of 2009 installed. And the additional civil judge, it could be in OS number 16 of 2015, has decreed the suit for partition, holding that the plaintiff, who is the appellant in this case, is entitled to half share in the suit scheduled property. Learned advocate for the respondent not to dispute the fact that the suit has been decided in the aforementioned manner. Under the circumstances, this appeal has to be allowed, and judgment and decree passed by the trial court decreeing the suit of the plaintiff has to be set aside, and so also the judgment and decree passed by the first appellate court dismissing the appeal has to be set aside. Formally, on substantial question of law, frame markobody. This, though this case is listed for admission with the consent of learned counsel for the appellant and respondent, this appeal is admitted to consider the following substantial question of law: whether the judgment and decree passed by the trial court and the first appellate court are sustainable. Any of the judgment and decree passed in OS number 16 of 2015 between the same parties in respect of the same properties.
Yeah, compromising the matter.
Yeah.
There is a compromise in the matter.
It is also stated by the learned advocate for the appellant and respondent that after the disposal of OS number 16 of 2015, the parties have formally agreed to settle the matter, and they are not, though they have settled the matter, the same is not reduced into writing. This judgment shall not come in the way of proceeding further with the settlement. ಏನದು ಐ ಏನು ಐ ಹಾಕಿದ್ರಂತಲ್ಲ? The application seeking at I number 1 of 2022 and 1 of 18 seeking production of additional documents are not pressed by the learned counsel for the appellant. Since the appeal is disposed of, I number 2 of 15 seeking temporary injunction does not survive for consideration.
43, AP Gita Devi.
Pasora.
44, Umesh.
ಏನಿದೆ? ಪಾಸ್ವರ್ಡ್ ಆಗಿದೆ. ಹೌದಾ? ವೇಟ್. ಅವ್ರ ಮಹೇಶ್ ಇದ್ದಂಗಿಲ್ಲ. 2:30 ಬರ್ತೀರಾ? 2:30. ಇದ್ಯಾವ್ದೀಗ? 2 ನಿಮಿಷ ಅಂತೆ. ನಿಮ್ದಾ? 2:30 ತಗೋತೀನಿ. 2:30ಗೆ 45 ನಾ? At the request of for the respondent. ಅಲ್ಲ ಅವ್ರು ಇದಾರಲ್ಲ, ಅವರು 2:30 ಬರ್ತೇನೆ ಅಂತ ನಾನು. 44 ಇದ್ರಲ್ಲಿ ಏನ್ ಪಾಯಿಂಟ್? ಲಾರಿ ಟ್ರಾಲ್ ಮಾಡ್ತೇನೆ. ಯಾವ ಮಾಡ್ತೀರಾ? The request of for the respondent, this is not on Monday.
Trial court dismissal.
Good.
Statement of the property is east to west 25 feet north, south 100. That has been purchased by the plaintiff under exhibit P1. Northern boundary mentioned in exhibit P1 indicate the property of Appajappa, Channappa, Vijayappa. After purchasing the property, they put up a construction measuring about 25 feet into 40 feet.
and maintains remaining extent on the northern side of the vacant land. Northern side of the vacant land. Having retained 25 feet into 60 feet, files a suit by contending, I am maintaining about 25 feet into 80 feet. Suit has been filed. And the day when the client has been presented, nobody knows what made the learned judge to appoint a commissioner. A commissioner was appointed, and in report has been secured.
On the basis of application.
No, on the basis of the plaint which has been presented by the plaintiff.
No, along with the plaint, there must have been an application.
No amount the court has appointed a court commissioner. It appears that the court has felt doubt with regard to the location and measurement of the property. After appointing a commissioner, secured a report. In the report submitted by the commissioner, he has stated he has filed the suit for 120. It's not so. Against his ownership of 100.
What is the description?
It is a Chitramandira.
No, width, length and width.
100 into 25.
Yes.
And he has paid the property.
Yes. Purchase the property under the sale deed. No, yes, purchase the property under the sale deed.
He says that he has fenced the property. Or he has fenced the
sale deed.
property.
Under the sale deed. What is the extent shown in the sale deed?
100 by 25 feet.
The same is shown in the plaint also.
The same has been shown as northern boundary here. The northern boundary is the property of Channappa in the sale deed of the plaintiff. That is exhibit P1. However,
Cinematography.
schedule furnished
Cinematography.
cinema. A cinema theatre go plaintiff property go much than the Channappan property. This plaint has been presented on 29th of May 2007. I have purchased the property located in between the property of Chitramandira and the property of the plaintiff.
Channappa's property.
From Channappa, that is under the sale deed dated 2/5/2007. That sale deed has been produced and marked as exhibit D7.
2/5, that is prior to the suit.
D1.
Prior to the suit.
Furnishing a wrong boundary, files a suit. Trial court found you have constructed 25 feet into 40 feet, and your property cannot, the vacant land cannot measure 80 feet into 25 feet. By virtue of filing the suit, you are claiming the property of someone also. In the meanwhile, he has also included the defendant number 3, that is the local authority. The local authority has maintained road on the southern side of the plain schedule property. The plaintiff had enclosed part of the property belonging to the local authority also in putting up construction. They have also produced documents showing that he has enclosed, and also the action taken by them, that is exhibit D5 and D6. Notice issue in order to avoid it, he came to be dismissed. The lower appellate court, without proper appreciation of fact, without reversing the finding which has been recorded by the trial court, approves the plaintiff because the schedule contained his measurement is 25 feet to 100 feet, and he has not claimed much more. Therefore, I will grant an order of injury.
Implication of boundary mentioned on the northern side is not considered.
Not been gone. Not been gone. That is all the question. Had he gone into all these things, had he looked into exhibit P1 and D1, would not have decreed.
Report is in your favor. Report is in your favor. Commission report. He has filed objection.
He is not filed objection.
Commissioner report is not in his favor. And one thing, Lord, is both plaintiff and defendant, Lord.
How many commissioners appointed? 2 or 1?
Only one.
C1, C2 and the other report is Allah.
C1, C2,
There are two reports.
D1 and D1 notebook, southern northern boundary notebook, sir.
But I am sufficient to your lordship. This both plaintiff and defendant not proper the site they are owning now was earlier not only one site was totally measuring 15,200. It was originally belongs to one Shantraj. Northern side portion lot was sold to Channappa, measuring 15,200, and southern side lot it was divided into that is 25 by 100, 2500. 2500 was sold to Rajan, and on the western side of that lot, it was sold to Italy. That's how that important point was missing from the record lot. I am having a copy of the JT. I want to produce it.
This year ಬಂದಿದಲ್ಲ
ಇಲ್ಲ ಇದನ್ನ ಮಾಡಿಲ್ಲ ಇದನ್ನ ಮಾಡಿಲ್ಲ
ಬಂದು ಹಂಗೆ ಕೊಡಕ್ ಬರಲ್ಲ.
I want to file an application for additional evidence.
The whole thing is Marat. D1 and D1 so far as northern boundary and is located in Turkey satisfies. That has not been gone into by the.
No, what he's trying to say is, probably what he's trying to say is, the answer to your contention lies in that document.
Yes, and it was only one side. Question of not the road existence of road.
Correct.
For defendant's property.
You
Does not arise.
have to make out a case for production of additional.
Yes, but that is what I wanted to file an application taking out the case for production.
Lengthy matter be admitted with case the paper road. Whether the lawyer of report was
Admitting now it is 2014 matter for final disposal.
All right. For 6 years, you are not produced the document, though your document is with you.
But they have not recently applied what
For 6 years, you are aware of all these documents.
file an application, but try to make out the case not a production property.
order was being passed by the legislative state. Only one page order, only one page order. No reasonings. First appellate court order.
Let me produce the document. I allow the production. Set aside the order. Remand the matter back to the first.
Yes, I also know objection.
So you are also satisfied. He is also satisfied. Is this matter on?
Tuesday or Wednesday. Meantime.
Seventh. First appellate ಕೊಟ್ಟು
My lord, the court mic is muted, my lord.
Yes. Yes. What is your stand? You are claiming title under the sale deed, or you say that your vendor had perfected the title by order?
Not only that, I also will not contend. My contention is also that corporation will not has not produced any document. They say that they are the owner, and what is produced is exhibit E3. Last time, I think, your lordship also saw the original. Please come to my lord, page 20. This is all the title deed for the Allah, small paper, otherly hakilo. It was small paper and E3. Original is here, my lord. Page 20. This, according to them, my lord, is the title that they have.
(1896).
No signature, no this thing, nothing. If there's a sale deed, there'll be a registered sale deed.
This is a extract from which document?
We don't know, my lord.
No, what it says is Register of Municipal Land.
Municipal lands and capital.
So maintained by municipality.
That is what they say, but there is neither, my lord, certified nor original also is here. Just have a look at it. No signature, no seal, nothing.
All right. You are not admitting the ownership of corporation. Then against whom you are seeking adverse possession?
Lord, I claim, my lord, ownership rights. One. Alternatively, my lord, I had claimed, my lord, adverse possession. I know that, my lord, it is destructive. So, my lord, if I claim adverse possession, my lord, I can't claim ownership. Ownership, my lord, I can't claim adverse. But then
my question is whether the plaintiff who has purchased the property,
yes,
is claiming title by adverse possession,
or no, purchase, my lord, in the year 1946. Successive sale deeds have been there. I have, my lord, given your lordship for the list of dates that I have given you.
Just a second.
Yes.
There is one more synopsis filed along with this field memo that contains elaborate dates and events. You can even refer to that.
Please, my lord.
Field memo. Yes, paper book. Along with the field memo, Mahesh Chandra, the synopsis which you have furnished.
Yes, my lord.
27 to 20. Yes, it is dated 27 to 2020. All right, now I got your copy.
1941. My lord, seal number 2. Venkat Swamappa was the original owner. He executed a will, my lord, in favor of Narayan Swami. Narayan Swami, my lord, got the surveyor. Surveyor, my lord, fixed the boundaries. The This is my lord collector of civil and military station. Deputed the surveyor. Statement of Venkatam Narayan Swami is recorded. Then of course, my lord, your lordship also had a doubt is whether the Shanbog Lingappa was, he was a Shanbog or only his name. That my lord, we are not able to. He's a Shanbog is what my learned friend says, Lord. If I can request your lordship, just to turn. Lord, can I persuade your lordship to turn to the paper book, page 144. He was a Shanbog of the village itself. Yes. Your lordship can come down.
144 is the examination chief.
Yes.
Yes.
142, my lord, it starts. I'm not mistaken. Okay.
Correct. Retired revenue inspector. Retired revenue inspector. Retired revenue inspector.
Yes. Please come to my lord, page 144. 6 lines from the top. I can identify the handwriting of exhibit P1B, means the handwriting, so also. Narayan Swami, he refers to that Narayan Swami. I know one Shanbog Lingappa. He was the Shanbog of 4 or 5 villages in the civil military station, including Blackbuddy village. I know his signature and I can identify this. So he was one of the Shanbog of the village itself. If I can persuade your lordship, come to one of serial number 4. Statement was given. Last time, I was not very sure whether he was a Shanbog or only a name lender.
Yes.
He was only his name was Shanbog. He was not a Shanbog.
Yes.
Then Narayan Swami wrote a letter to the superintendent of land records, to the collector for survey and demarcation. Then they got the survey demarcation made. Serial number 9. That serial number 10. Page collector letter addressed by the collector C&M. Whereas conducted survey of survey number 16, 18, and 25.
Prakash Chandra.
Yes, my lord. Yes, my lord.
You're audible?
Partly, my lord. I'm sorry.
No.
Better, my lord. Better, my lord.
Yes.
Oblige me.
Am I audible?
Yes, definitely.
Yes, thank you.
You are audible even otherwise.
You're audible even otherwise. That's what he says. Even to the next court also.
I used to jokingly say, lawyer even loud voice
My father and grandfather, they had very loud voice. Unlike me.
Same thing with my father also, not very loud. Not my grandfather was also a lawyer. He also had in fact, he was even lower decibel than my father himself. Then my lord, serial number 12. Narayan Swami formed my lord 12 sites.
Yes.
In fact, my lord, that village officer, his statement is my lord 10/7/1946. Ali 11 Ali. It is my lord 10-7. Exhibit P15 is 10-7-1946. Narayan Swami my lord formed 12 sites. Record of rights was transferred in the name of Doreswami Iyengar, my lord, who was the vendor of the petitioner. Correct. Because Narayan Swami sold one site, which is the scheduled site, my lord, in favor of Doreswami. From him, my lord, Doreswami Iyengar purchased it from him. Then, my lord, 9th of August 1948, letter addressed by the executive engineer, civil and military station to Doreswami Iyengar. More important is, my lord, page 4, serial number 15. Notice was issued by, my lord, the corporation itself, the Doreswami Iyengar, stating that the vacant site on Thimmaya Road will be assessed to property tax from October 1950. This is, my lord, the corporation itself, my lord, issued the notice. Then 3/12/90,
Plaintiff's vendor.
Then, my lord, 3/2/1952, notice dated 3/2 was given
So
by
when
the
the
revenue
plaintiff,
inspector.
when the plaintiff purchased?
My lord, serial number 12, my lord.
46.
Yes.
Why the notice is sent to the plaintiff's vendor?
What my lord is asking is, why was
So the plaintiff has purchased property in 1946. Why notice relating to assessment of land was sent?
what the learned judge is asking is, 46 he purchased it. Why was the notice sent in 51?
Notice sent to the vendor.
This is my lord 1951.
Yes, understood.
46 in the 1951. Ashtu gap yake anta tab kelta irada.
No. The property was purchased by the plaintiff in 1946.
No. Doreswami Iyengar, my lord.
So when the plaintiff purchased, that's my question.
73.
23, all right.
Yeah, let's just get that, my lord, that running page.
All right, then fine.
27.
I thought plaintiff
No,
purchased
I'm sorry. I mistook your lordship's question itself. Sorry. Then, my lord, on 3/2, notice was issued by the revenue inspector calling upon Doreswami Iyengar to appear for hearing. Then,
Which hearing for assessment of property tax? Yes.
Then, my lord, an endorsement came to be issued on 21/4/1952. Endorsement came to be issued by the revenue inspector informing Doreswami Iyengar that the taxes on vacant land in Thimmaya Road has been reduced.
Yes.
Then, my lord, on 28/5/1956, letter addressed by the Tahsildar to Deputy Commissioner that no records of acquisition of land, and that the Kata of the, my lord, survey number 16 stands in the name of Doreswami Iyengar, and that they have built houses thereon and have been in possession since a long time. Then, my lord, please come to, my lord, the serial number 28. Various letters are referred to, my lord, all of which show that, my lord, Doreswami Iyengar was, my lord, the owner of the property. In fact, if your lordships come to, my lord, serial number 21 for a minute. Detailed inquiry report is submitted to the revenue inspector that Narayan Swami and his predecessors in title have been in possession and enjoyment of the property for the last 8 years. And 22, on 5/8/1960, letter was addressed by the Tahsildar to the Deputy Commissioner that the record of rights, my lord, stands in the name of Doreswami Iyengar, that the corporation has not established this right. So one of the things that we are contending before my lords is 1960, my lord, when it was specifically, my lord, informed to the corporation that they are not the owners, they should have filed a case within, my lord, 12 years. Not having done so, my lord, under 27 of the Limitation Act.
No, just a second. Yes. On 5/8/1960, Tahsildar addresses a letter to the Deputy Commissioner.
Yes, sir.
And he says corporation has not established the right.
Correct.
Was there any dispute between the corporation and Doreswami Iyengar?
Corporation, yes, corporation said I am the owner of the property.
Is there any dispute relating to the title before the Tahsildar?
Strictly no, my lord. Because as your lordship saw, my lord, all these from serial number 15 to 20, all of which, my lord, corporation itself, my lord, says that you are the owner.
That is understood. And what made the Tahsildar to write an address?
Hey, my lord, obviously, my lord, thereafter must have said serial number 23. Aditya, Stellar, Adu, my lord, what has happened is suit has been filed, my lord, in the year 2000, my lord, 94. 74, huh? Sorry, 74. 1962 records alla. Estidio Aston Hakidaro.
That is understood. Why the deputy commissioner, or sorry, Tahsildar writes a letter to the deputy commissioner stating that the corporation has no title. What made him to write? No, on his own, he can't write such letters.
No.
Somebody must have prompted.
Somebody must have, my lord, prompted it, and therefore, my lord,
What was the cause? Mr. Prashant Chandra, why the Tahsildar writes a letter to the deputy commissioner stating that the corporation has no title?
I'm sorry, I may not be able to answer that right now because firstly, I'm not able to get that serial number which is referring, which.
No, he has given the dates of date synopsis containing dates.
58-1960 Exhibit P38
He
and
is referring
39.
to. He is
Page
referring to
250
his.
and 253.
He is referring to dates of events submitted by him.
Yes, my lord.
I think it was submitted with last hearing.
Yes, I gave a copy to my learned friend.
Illa, ನನಗೆ ಬಂದಿಲ್ಲ ಅದು.
Not your dates. Not
ಇಲ್ಲ, I
your
have
dates.
not received that.
Dates ಕೊಡ್ಲಿಲ್ಲ ತಮಗೆ.
ಇಲ್ಲ, ಇಲ್ಲ.
Last time ಕೊಟ್ರಲ್ಲ.
ಇಲ್ಲ.
ಕೊಟ್ಟಲ್ಲೇ ಕೊಟ್ಟೆ. ಇಲ್ವಾ? Sorry.
No. Because that's
normally, my lord, whatever I give to the court, I give to the other side also.
I have got 2 copies. If you can't come to court, I'll give.
My lord, my colleague is there, man. He's sitting in the court hall. One Mr. Ganesh is there. Sorry, my lord.
You can take this.
My lord, page 250. Yes, my lord, to get a clarity. Down paper book ಅಲ್ಲಿ. P38.
$238. 238.
Yes.
The British Empire.
Allah, sorry. Page number 250, P38. Petitioner 38.
250. Exhibit P38.
This
was a letter. P43 ತಾವು ಬಂದ್ರೆ that may give some idea. Page 272. Copy of the letter dated 28th of October 1957 from the Engineer Corporation City of Bangalore to the Deputy Commissioner against resurvey number 16 and 18 of the Blackpatty village of Bangalore North Taluk during the record of rights survey in the record of rights register. Resurvey number 16 of the said Blackpatty village was 21 as per original survey records of 1870 and the Karda was 1 Venkatappa as per entry in the original Parthi book. Serial number was changed from 21 to 18 when the surveying was done of the area. Of that area was conducted due to the enlargement of the Miller's tank and subsequently it was changed to 16 during the resurvey of the said area. Extent of resurvey number was enlarged from 1 acre 20 to 8 acres 29 hectares. Then the said resurvey number 16 was treated as Kharab because of the tank. Water was covering the whole area of the said survey number, so on and so forth. Then, my lord, they say page 273 and serial number 3.
This is essential in application for measuring the property.
Oh,
that's all.
So based on that, my lord, they conducted some inquiry and all that, and they said, and it was also communicated to the corporation, seal number 24 of my historians. Letter was addressed by the Deputy Commissioner of the Corporation asking him to prepare an application before the Tahsildar if they are disputing the entries. Then more important is, my lord, even after that.
Who is that? Maharama Corporation?
So, Maharama Corporation, my lord, was a tenant of our, my lord, it's not the corporation, my lord, the city corporation. That was, my lord, a tenant of,
Right.
the tenant to the tenant of, tenant to anta ಇದೆ.
Tenant of your vendor.
Yes. Similar address, my lord, was written also by the other tenants. Then, my lord, lease deeds are there, my lord, because there is a building existing.
What made you to file a suit?
Ultimately, my lord, please come to, my lord, page 7, serial number 30. I purchased, my lord, in 73. Serial number 28, my lord, if you're not come to, sorry, I should have.
27.
Yes. Registered sale deed was executed Doreswamy Iyengar in favor of, my lord, the respondent before your lordship. Letter addressed by Doreswamy Iyengar to the tenant Syed Yusuf that he has sold the property to the plaintiff and that his tenancy is accounted and that he should pay the rents to the plaintiff.
When this property was sold, was it a vacant land or contained a structure?
Building existed, my lord.
All right. Pursuant to this sale deed, the khata was changed.
Ali Madlilla and we filed this. My lords, my lord, can I pursue it? Lordships, look at, my lord, seal number 24 for a minute. Alene, Mele. Maharama Corporation, my lord, was a tenant of the Doreswamy Iyengar. Therefore, my lord, there was existing building and there are other lease deeds also which we have produced, my lord. Seal number 25, 26, all that. Then we sought, my lord, after purchase, sought for transfer of khata in our name. That was refused, seal number 30. That is when the cause of action arose and we filed the suit.
His argument is your vendor's vendor claimed to be a legatee. Will is not established. That's his contention.
That's what, my lord, they are saying. My submission is, my lord, they have, my lord, not established any title at all. Their only, my lord, document is this. My submission is from 1946. There are, my lord, successive documents, including, my lord, the documents, my lord, given to us by the corporation itself in the form of letters. That
what is the cross-examination addressed on the document which they claim to be their title deed? That is municipal register.
I just point out. The lords may take, my lord, the page. Exhibit, they examined, my lord, one here. That is 173. 173, my lord, and cross-examination I'll point out.
When you are plaintiff, claim adverse possession against whom?
Lord, we claim, we said we are the owners and also claim not adverse possession.
Against whom?
Not against the corporation or against the entire world. I don't know. Trial court held that, my lord, will is not proved because you did not examine, my lord, the testers, my lord, 1942 will, my lord, everybody is dead. And therefore, my lord, it held that, my lord, I have perfected my title by adverse possession because your will is not known. My submission is, my lord, I'll give, my lord, 2 judgments. In fact,
Prashant, just a second. If your title is not established,
Yes, my lord.
It's not established.
Yes, my lord.
And that the plaintiff's title is also not established.
Yes, my lord.
Remain says that he is in possession since long.
Yes, my lord.
We have to apply section 110.
My lord, I'll reply after this. I want to know what exactly is the stand. Is he taking twin stand or single stand? I wanted to see that.
Now his stand is very clear. What he says is corporation is not having title. Assuming that we have not established the title, or possession is established because possession is admitted.
Yes,
we are not disputing the possession.
Yes.
So you don't have title, he doesn't have title. So who is in possession should be treated as the owner.
My lord, my title being not there is not an issue, my lord. He has come to the court with a declaration.
All right. He has established
He is
possession.
seeking declaration.
No, if you can establish your title, that's fine.
Yes.
If you're not able to establish the title, then what is the position? Section 110 will squarely apply.
It will not, man, without the great respect.
110 of Indian Evidence.
True, my lord. I would reply on the next statement. Let me. That's why I'm eagerly waiting for him to complete as to see whether he's saying adverse possession or title. I'm keen to know because he can't carry both. He can't be in two boats at the same time.
One judgment, I give you a lordship. Maybe, my lord, the law will ultimately change. Let me just pass on one judgment where, my lord, title was claimed. The Supreme Court held, my lord, that he has perfected his title by adverse. Please have a look at it. My lord, please come to page 95, my lord. 1973 SCC 802. There was a grant, my lord, made in favor of, my lord, the person. That is, my lord, Dalhousie Institute Society. What happened is, they said, the grant is not true. But since you have been in continuous possession for more than the period of limitation, my lord, term and adverse possession, my lord, is what they have said. Can I persuade your lord to come to, my lord, paragraph 16? 1-6.
So now this Ramajanmabhoomi case is holding the field and it comes to the
I know
question
that.
related
I know
to
that.
this.
No, all that I'm saying is, law might change because my lords are aware, my lord. Earlier view was all along, my lord, for the last nearly about 100 years, it can be used as a shield but not as a sword. They upset it and they said it can be used as a sword and you can file a suit for specific, but for declaration that you are perfect, your title by adverse.
In anticipation of this judgment, you have already filed a case.
Paragraph 16. Just have a look at it and then there's one more judgment which I will place before your lordship. Page, my lord, 100. There's no material placed before us to show that the grant has been made in the manner required by law. So as a fact, a grant of the site has been made in favor of the institute. Evidence relied on by the special land acquisition officer, judge, and the High Court also clearly established. Respondent has been in open, continuous, and uninterrupted possession and enjoyment of the site for over 60 years. In this respect, material documents evidence referred to by the High Court clearly establishes that the respondent has been treated as owner of the site, not only by the corporation but also by the government. So is the case here in our case. The possession of the respondent, which no doubt is invalid in law, as to what exactly is the legal effect of such possession has been considered by this court in my lord AR 1970-51 Supreme Court 469. The position of the respondent corporation and its predecessor title was that a person having no legal title but nevertheless holding possession of the land under the color of an invalid grant of land in perpetuity, free from rent from the person for the purpose of a market.
So the question is,
not being referable to any legal title.
the question is whether the basic ingredients of adverse possession have been brought in evidence.
Lord, adverse possession, my lord, is I must, my lord, prove that I was having hostile title to the corporation. I was, my lord, in open enjoyment of the property. Hostile to, my lord, the respondent.
Not hostile. You are carrying the impression that you have purchased the property.
Lord, that, my lord, there was a dispute between me and the corporation is evident from the fact that corporation writes to the Tahsildar.
All right. All along,
holds an inquiry.
no, all along, you claimed right to the property based on the sale deed, not based on adverse possession.
Therefore, I said, this judgment, I claim, Lord, right over the sale deed. And, Lord, if the sale deed, they say, well, it's not, because your will is not true. Lord, I perfect my right.
Hostile intention is not forthcoming.
Lord, what is the intention? That, Lord, I must, Lord, be enjoying the property.
Everything done.
Uninterruptedly.
Interrupted, continuous possession.
And hostile, because, yes, Lord, hostility. Your Lord, just have to make serial number.
No, to say it is hostile, the first instance you must admit that the property belonged to corporation. That's not your case at all. What you are saying is, you have purchased the property.
Correct.
And your vendor's vendor acquired the property under the will.
What I am submitting before your lordship says, corporation, my lord, comes and says, I'll refuse to transfer the kata in your favor because I am the owner of the property. My lord, before that, my predecessor, my lord, in title, they, my lord, again, my lord, raised this very bogey. Having done that, they will.
Your predecessor in title claimed right over the property under a will. There was no hostile
No,
assertion.
let me point out. No, it is hostile because, no, he claims plot under the title plot in his own right because he says that I have purchased it from Narayan Swami. No doubt at all.
Narayan Swami under the will.
Under the will.
So nobody admitted the title of the corporation.
No.
So when that is the case, there is no question of adverse possession.
Lord, what
Unless you say that.
No, I understand. My submission to your lordship is, I also, my lord, my claim is, my lord, in the alternative. One, I claim, my lord, that the will is proved because it's a will of, my lord, vintage. And therefore, my lord, there is a presumption. All, my lord, attestors have died and therefore, my lord, it has to be the trial court's finding that, my lord, the will is not proved, my lord, is not correct. And therefore, I am entitled.
Attestors have died. There is another way of proving the execution of it.
I agree. But then, my lord, what is the other way? None of them are existing. Nobody, my lord, 1940, please understand, my lord, after 35 years.
All right. Let us assume that you are claiming your vendor's vendor had a title under the will. Let us accept that. Then you must give the claim relating to adverse possession. You focus on only one point, either ownership under a registered sale deed,
But there are,
traceable to
I
your vendors.
understand. But I cannot also claim, right, under, my lord, section 27 of the Limitation Act.
Section 27 has to be read along with Article 65.
Lord, I can only draw your lord's attention. The very fact that, my lord, the corporation, my lord, came and said, I am the owner of the property. They should have filed, my lord, a suit within 12 years. Not having done so, my lord, they lose their right. And therefore, my lord, they have no right over it. Please look at it.
What is the starting point of limitation under Article 65?
But starting point would be when they claim that they have, my lord, a right over this property.
When the possession of the dependent becomes adverse.
Lord,
Article 65 is very clear. Article 64, suit for possession based on previous possession.
correct.
They have to file a suit.
When, my lord, that when the possession of the defendant becomes adverse to the plaintiff, it became adverse, my lord, when I am in possession of the property. I, my lord, am continuing to, my lord, enjoy the property.
As long as you claim to be in possession as a owner, the possession is not adverse.
That, my lord, word adverse, should it be that, my lord, it is used in the English language, my lord, terminology of adverse. I would submit that, my lord, it should be, my lord, because adverse is, my lord, I have, my lord, an adversary, adversarial, adverse. So, my lord,
What you are trying to say is, corporation did not permit you to occupy the property as a licensee. You went there on your own, so the possession became adverse. It's not a case that they have given you the property on lease or license.
no, certainly not. That is not their case also.
It is not under their permission.
Correct. Therefore, my lord, my submission is 20, my lord, when they claim, my lord, right, and the Tahsildar said, sorry, you are not the owner, the Narayan Swami is, they should have filed, my lord, a suit within 12 years. Not having filed, section 27, my lord, if they don't file it, they lose their right over the property itself. Then, my lord, question would be,
Read section 27.
yes, and the determination of the period hereby limited to any person for
All
instance.
right. The important phrase is determination of period hereby limited.
Correct.
What is the period limited? You have to go to 65.
Yes.
Article 65.
Yes.
So under Article 65,
Possession of immovable property or any interest based on title, 12 years, when the possession of the defendant becomes adverse.
adverse.
That's what I'm
So-
saying.
So the principle that has been laid down, interpreting Article 65 and Article Section 27 is the suit for possession based on title cannot be dismissed unless the defendant establishes adverse possession. That is the law laid down.
Slight distinction, my lord.
You can make out, but this is the law laid down. See, earlier there was the phraseology was different, phrase was different under the earlier limitation.
Correct. I know that.
So this Article 65 is amended, or the new article, Article 65 under the new act. The word, the expression, the date from when the possession becomes adverse, it was not found under the earlier act. Under the earlier act. So the law was like this. If you are not filing a suit within 12 years from the date on which you are dispossessed, then your suit is barred by limitation. The 1963 Act deals with two provisions, Article 64 and Article 65. Article 64, suit for possession based on previous possession. So if you are not having title of the property, You are claiming possession only based on previous possession. Then your suit has to be within 12 years. But under Article 65, the owner's independent to establish already perfected his title of adverse possession.
Can I put it in this manner? I probably did not convey what I have in mind. There was the corporation. Today, there are two sets of claims. One by me, saying that I am the owner of the property by virtue of all these title deeds, will, sale deed, then the second sale deed in my favor, and therefore I become the owner. Corporation says it is the owner of the property, having purchased in 1896 or 1890, and therefore it gets title. So there are claims and counterclaims. One. Now,
So whether the corporation claims it has purchased the property,
yes, that is their claim. But can I pursue just get the registration?
all right, that's the reason why I'm saying they are trying to say that they are the owners of the property under a sale deed. That sale deed is not produced. And if you are saying that you are also the owner of the property under a sale deed or traceable to the title traceable to the will of your vendors, something like that. And assuming that both have not established the title.
Then possession, my lord.
Yes, section 110.
That's all that I would say.
Probably,
Either way, my lord, looking at
probably you have got a weak case on adverse
because of adverse possession.
Probably a case on section 110, adverse possession, or you are claiming under 110, or you claim that you claim that you have established the title.
Can I, my lord, in that event, request your lordship, give me, my lord, let me do some more research on that section 65, whether, my lord, that word adverse, what is it? Let me, my lord, there's one or two judgments, my lord.
Indira versus Armugam.
I know that. Adi there, plus, my lord, that Tagore lecture.
Indira versus Armugam, very short judgment, maybe 10 lines. No scope to distinguish on facts.
But that's
1999.
Sorry, I'll just make a note of it. I think I have seen this.
Indira versus Arumugam, something like that. Under Article 65.
Because your lordships will be laying down some law. So, my lord, let me, my lord, assist your lordship properly. Then adverse ಅನ್ನೋದು ಹೇಗಿದೆ ಅಂತ ಹೇಳಿ.
On adverse possession, the law is settled.
Not that. That 65 and 27.
Even Article 65 is very clear.
No. What happens is
the word used in the judgment is 1963 Act, Limitation Act. After 1963 Limitation Act, the metamorphic change has gone into place. That is the expression used, referring to Article 60.
Correct. But the terminology, there is no definition of word adverse in the entire Act. So,
common law doctrine is not defined under the Act. It's common law doctrine. Sri Devala Learned Senior Counsel for the respondent, and that is request this matter on in part and in part.
First week ಅಲ್ಲಿ ಯಾವಾಗಲಾದರೂ ಆಗಬಹುದು 6th or 7th.
6th.
Further
record. 6th.
Obligation.
7th ಆಗಬಹುದಾ 6th
7th. Also. Also.
I don't have knowledge.
Let him come. Bargain is present. Pass over. For the appellant seeks a short accommodation, requests the matter to be listed on Tuesday. This matter on Tuesday. So no more adjournments in further hearing matters. So comments. This is the same case where you said that the matter has to be remanded. Not maintained. You are plenty for defendant. There are two suits. Where is the synopsis? You are the defendant in both the suits. Plaintiff is same.
No, plaintiff is different. In the first suit, my brother is the plaintiff. The second suit, my mother and one sister are the plaintiff. Second suit is for partition of all the properties. Listed items 24 Mr. items. The first suit, which is the suit under which I'm filing this. Now, in the first suit, the brother has filed a suit against me and another brother saying that partition took place in the year 1980 by way of an unregistered partition. 7 items of the constitution properties now are allotted plaintiff, and I am over that land in possession.
So that was a suit for declaration of title based on the previous partition. By the brother against the brother.
Brother against two of his other brothers. Now,
Parents are not there.
father is not allowed.
Mother was a dependent.
The brothers are.
All right. Mother was not a party. Mother is not allotted any share. Mother was alive. Mother was alive. All right. What is the second suit? By whom? Yes. All right. So what happened to the suit for declaration injunction?
The same because I formal judgment. In the second suit for partition, the plaintiff is not. The other defendants did not need it. It's based on whatever is being.
In the first suit. Suit is dismissed.
However, is also finding against.
The evidence was recorded by clubbing both the cases.
And it's also.
So you mean to say that only the plaintiff in the first suit, declaration suit, he led evidence.
He led evidence.
Rest of the parties did not lead evidence.
Plaintiffs in the second suit did not lead.
As a defendant in the first suit, did they lead evidence? So when the case was clubbed and common evidence was recorded, how do you say that the evidence was not led in the second suit? In the second suit?
Because the plaintiff has not led it. I'm only talking about plaintiff not leading it. Because they want.
Plaintiff in second suit. But they were the defendants in the first suit. The plaintiffs in the second suit.
Plaintiffs in the second suit have not led it.
No, were the defendants in the first suit.
No.
Understood. All right.
The plaintiffs are plaintiff is in the first 3 brothers. First brother, one of the brothers has filed a suit against both of his other brothers saying that partition took place in the year 1980.
How many brothers? 3 brothers. So out of 3, 1 brother filed a suit against remaining 2. That is the first suit. OS number 2000. All right.
126 to 1998, but
All
it
right.
was transferred from Mandya
136 of 1988. 88. Ah,
98.
okay. This suit is decreed.
This
What is the second suit?
second suit is OS 73 of 2001.
This is by wife and the remaining children.
Yes, the father, yes, mother. So it's filed by the mother and one daughter.
Against all the brothers. Against all the. All right. All right. Now both the cases are clubbed. Common evidence is recorded. Plaintiff in OS number 301 leads evidence. And defendant in OS 301 also leads evidence. All right. Then OS 7301 plaintiffs do not lead evidence.
And one of the defendant in OS 71 sister, she claims certain properties, her own self-acquired property. She also does not.
No, OS 301 is decreed. 73 is dismissed. Common judgment.
There are findings that I can claim in OS 70. That's other properties where myself defendant number 1 in 301. Now there is a finding against me saying that it's not self.
Right.
However, I could not find an appeal against.
No, just a second, madam. In OS 301, you took a stand that one of the properties is self-acquired property.
There were 7 items.
All right.
There were only 7 items in 301.
Suit for declaration, right? And the court says there was also a joint family property allotted to his share. Yes, and allotted to his share. Yes. Your defense was it was not the part of the partition scheme because it.
Denied the partition.
Yes. All right. Then you preferred appeal against only 301.
Not find an appeal against.
Because suit was dismissed. You are the defendant. So appeal is held not maintainable because you are not challenged this thing.
Because there is no appeal against.
So being the defendant in OS number 73, did you claim partition? In the written statement? So you also did, in earlier suit also you denied the partition of earlier partition setup. So being a defendant, you claimed partition. So your claim was rejected.
My claim that I discussed certain self-acquired properties of mine.
In OS 73, you claimed partition. You claimed partition being a defendant.
Yes, and
Not much of distinction in a suit for partition. Defendant is plaintiff, plaintiff is defendant.
yes,
And when you make a claim that you are also entitled to share, because share is not granted, you could have preferred an appeal against.
that's not policy. That's what citations that are.
Now this appeal is dismissed only on the premise that you are not preferred appeal against the second suit.
Not maintainable, not maintainable because that has been a comprehensive and that has already been. Besides, I cannot I cannot give a judgment on this because that appeal has.
No, I didn't get you. What you said?
What I'm saying is.
No, what the first appellate court said?
First appellate court says the partition suit has reached finality. Therefore, because that has reached finality, because no appeal has been filed, I cannot decide this because it doesn't become unvalid.
Understood. Now, what you are trying to say is you could not have preferred an appeal against a decree which is in your favor.
I could not have filed an appeal against.
Because suit is dismissed. Being
whether this rest to be.
but how this second appeal is appeal against the second judgment is not maintainable. when your claim for partition is dismissed, rejected. In the return statement, you claim partition, right?
This is what the judge says. It's only against the decree. If the decree is against, even if the findings are also against, some of the findings are against, the decree is in my favor, I cannot file an appeal first appeal session.
The decree is not in your favor in this case.
Decree is in my favor because it's been discussed.
No. See, you can't just use the word dismissal in decree, plaintiff and defendant.
There are two things here.
Understood.
I am the defendant.
Yes. So merely because you are a defendant and the suit is dismissed, straight away you can't say that the decree is in your favor. In a suit for partition, when you make a claim that you are also entitled to share, the decree for dismissal is against you.
Let's look at this judgment.
Yes. 2:30. Just inform him in case if you come across who is the case for respondent. Shiram, you come across him, it's inform him. Respondent. ಏನಿದೆ? Bill number 3 na? 5. ಏನು? 2 of 18 ಏನು?
All portions are said free of to the because I number 3 of it. Are you discussing?
So 3 of 18 and 2 of 18 both are disclosed. The net concept for the petitioner would submit. Sorry, respondent.
2 of 18 and 1 of 20. But by same one Umeshaya for impleading have been discussed. There are 2 IS for impleading by Umeshaya. I number 2 of 2018.
Two of 18 is for impleading, right?
Yes.
That is rejected.
Send in the order. 3 of 18. Order. Right.
Will add ಮಾಡಬೇಕು. Continuation. Learned concept for the petitioner does not dispute this aspect, and learned concept for the respondent does not dispute this aspect. Accordingly, I number 2 of 18 need not be listed in the cause list, and the application is already rejected. Yes. Next, ಮತ್ತೆ ಉಳಿದಿದ್ದೇನಿದೆ? Memo ಇದೆಯಲ್ಲ, memo. No, there are 13 notes. 3 ಏನು? Memo dated 10/7/2020. Memo dated 10/7/2020 for production of amended probate petition is accepted. Yes, yes. Then 2 of 2020, administrator. So I told you to verify all these things. There are 13 notes in this case. Who filed the application? 230 ಬರೋಕೆ ಹೇಳಿದ್ರು. There are 13 notes. Please verify. 13 38 therefore appellant. The request of appellant comes for the respondent. Justice matter. 2 weeks.
They have filed a statement of objection. Served a copy. Next Friday, I am ready to hear on it.
Statement of objection for what?
For appointment of
DNA test. It may not be conclusive and I have to certain.
You're opposing?
Only I will restrict that. That may not be conclusive.
On that, I will get some more notes.
But it can be conclusive also. Depends. Depends. Sorry? No, for some reason, the DNA of a sister matches with the DNA of another sister. Then what is the conclusion?
What is the percentage of matching?
Let the expert say. If he says that it is not permissible, then we'll accept his report instead of re-speculating, right? Shall we allow the application? You can cross-examine. You are not satisfied with this report, you can object and you can cross-examine him, you can grill him. You can make him repent for having become the expert. All things are permissible. This is matter on Monday. 53. Hmm. 7 at the request of relevant person for the petitioner. 2 weeks time granted. ಏನಾಯ್ತು ಹೇಳಿ?
He has to liable to task.
Appellant. Correct, understood. No difficulty. See, the court says, registry says, you are not approached the registry seeking release of this amount.
And the filed application and voucher is already filed.
Concerned advocate for respondents has filed the refund voucher, but not approached the court, but not approached.
ಎರಡ್ಮೂರು ಸರಿ ಹೋಗಿ ಕೇಳಿದ್ದೀನಿ ಅವರು ಈ ಕಾರಣಕ್ಕೋಸ್ಕರ ಇದು ಅಮೌಂಟ್ ಡೆಪಾಸಿಟ್ ಮಾಡಿಲ್ಲ ಕೊಡಕ್ ಬರ್ತಿಲ್ಲ 25,000 ರಿಲೀಸ್ ಮಾಡ್ಬೇಕು ಈ ಅಮೌಂಟ್ ಯಾರು
Respondent died ಅಂತ ಆಗ್ಬೇಕಾ? What is the mistake?
309 ಅಲ್ಲಿ ಹಾಕಿದ್ರೆ 308 ಅಲ್ಲೂ ಆಗ್ಬಿಟ್ಟಿದೆ, ಅದು ಅಲ್ಲಿ ಇದಾರೆ, ಡೆತ್ ಆಗಿದ್ದಾರೆ ಅಂತ ಹಾಕ್ಬಿಟ್ಟು
Death ಆಗಿಲ್ವಾ?
ಆಗಿಲ್ಲ, 308 ಅಲ್ಲಿ ಇದಾರೆ.
308 what is alive?
Yes sir.
309 ಅಲ್ಲಿ respondent is dead. Respondent.
Yes sir.
ಏನಂತ ಆಗಿದೆ ಈಗ?
Yes, filed a memo. 309, no? The R1 is dated next day.
File application. 8 kind. Mr. Judiciary has filed a report. This is regarding the office should not mention the note regarding disposal IA. Therefore, some report has made a note to Mr. General to make a submit his views.
Relating to what?
Regarding the office, while mentioning the note 6 side, they never used to mention the disposal of IAs.
That is complied now? That is complied ಈಗ?
That's complete.
Seal number 8, note number 8.
9, 10, 11.
Register Judicial has filed a report as per the order dated 16/3/2021. Same is accepted. Then next.
9 notes witness list.
Allowed.
Filed by the respondent.
You have not filed application.
Report has been filed. 9, 10.
10 is what?
He has filed his report.
Why was appointed?
Whether the matter is referred to the project director.
Central, What is it?
For recording evidence, etc.
What is this?
Yes, said can be referred.
Yes.
Not record to judicial functions.
All right.
That is submitted.
All right. The report of the amicus query. The report dated 27/3/2021, filed by the amicus query is accepted. Yes. Then
Chief of Court filed by the respondent now very recently.
you are cross-examined. You are cross.
11, 12, 30.
13 allowed. Warning allowed.
That's all. Sorry.
Fine. Number 51 is stated that the unit for the respondent number 1 is not keeping well. Is this not wrong? Coming Tuesday, na? Tuesday. Madam, see, go to the definition of decree. Decree is defined, right? Adjudication of all controversies. So whether it is a dismissal or decree, whether a plaintiff or defendant, hardly matters. Once there is a decree adjudicating some controversies, and if you are aggrieved by that decree, don't go by the terminology that is dismissed, I am the defendant, is decreed, I am the plaintiff, then probably you ought to have filed an appeal. Aggrieved. But if you now in your written statement, have you made a claim to seek partition? Partition. That is for certain properties. You claim to be self-acquired. For other properties, you say that there has to be a partition. No. No, that is only for certain properties. Your claim is that it is self-equivalent. So my only anxiety is this: if there is a prayer for partition, being the defendant, that is permissible, right? All they have to do is to pay the court fee. There need not be a specific counterclaim as it happens in other cases. So if that prayer is rejected, then there is a decree which is against you, which could have been questioned by filing an appeal. Now what you are saying is suit is dismissed. No, it is only in respect of certain properties. For certain other properties, your prayer was to have a partition. See, out of admitted joint family properties, so there can be an alternative prayer. The word alternative is wrongly used there. So essentially what your written statement means is declare certain properties as the self-accord properties, and in respect of other properties, grant a decree for partition. So that prayer is rejected. So you are aggrieved under section 96. No, if it is a suit for injunction or just a suit for declaration of title, it can be understood very simply that there is nothing against you because the plaintiff's prayer is rejected. Now, in a suit for partition, plaintiff is dependent in the plaintiff. In the sense, anybody can seek partition. So, in that event, you have made a prayer. It is not that you have not made a prayer. You have made a prayer that partition is to be granted in respect of certain properties. Forget about the declaration which you sought relating to the self-acquisition. Ignore that. This prayer for partition is not accepted. So that amounts to a decree against you by referring to the definition of decree as found in section 212. Decree is adjudication of controversies between the parties. So that controversy is addressed, stating that you are not entitled to share.
Controversy, it's not about not entitled to share. I am dismissing the suit on the ground that this is a prior partition.
That is understood. So the controversy is adjudicated in the sense the court says that you are not entitled for share because the prior partition has taken place. So you could have challenged that decree.
No, I can't challenge. If I could have challenged it, I can challenge it.
You could have. No, you are going by just terminology where the decree says suit is dismissed, you are the defendant, you are not aggrieved. But in fact, you are aggrieved. The test is whether you are the defendant or plaintiff is not the test. The test is whether the suit is dismissed or decreed is not the test. The test is you are aggrieved or not. In that sense, you are aggrieved because your prayer for partition is rejected. Just examine on this point.
Present, he has to file an IA only through online transactions. Details ಎಲ್ಲ ಕೊಡ್ಬೇಕಲ್ಲ.
In online application ಹಾಕುದಂತ ಈಗ. ಅದು bank details ಕೊಡಿ. It will be credited to the account. ಆ ರೀತಿ ಮುಂಚೆಂಗೆ ಚೆಕ್ ಕೊಡೋದು ಎಲ್ಲ ಇಲ್ಲ ಈಗ. ತರಿಸ್ಬಿಡಿ. ಅಲ್ಲ ನಿಮ್ಗೆ ಯಾರು ಕೊಡೋಕ್ ಆಗೋದಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು? ಯಾರು ಕಳಿಸ್ತಾ ಇಲ್ಲ? ಹೂ ಇಸ್ ರಿಫ್ಯೂಸಿಂಗ್? Correct. Now, see, now there are some changes in the procedure how the payment is made. You have to furnish your bank details. It will be credited to the bank account. So now go there. Everything is resolved. ಇಟ್ಟೆ ಕೊಡ್ತಾರ ಅವ್ರು, ನೀವು ಹೋಗಿ See, now something is required to be done from your end. In the sense you have to furnish the passport. ಇವಾಗ ನಾಳೆನೆ ಕೊಡಿ ಪೇಮೆಂಟ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ನೋಡೋಣ. The matter is listed on the premise that rupees 5,000 cost is not paid. The cost is not paid. The respondent is at liberty to secure the decree for recovery of cost. The registry to disperse the amount of rupees 25,000 deposited by the appellant in favor of the respondent after securing the details relating to his account. Without delay. ಬೇಡ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ ಮತ್ತೆ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಇದೆ ದಯ ಮಾಡೋದು ಬೇಡ ಬಟ್ ಡೀಟೇಲ್ಸ್ ಯು ಹ್ಯಾವ್ ಟು ಫರ್ನಿಶ್. ನಮ್ಮ ಇದರಲ್ಲಿ this appeal is listed by the registry stating that rupees 25,000 kept in deposit, rupees 25,000 deposited by the appellant towards arrears of maintenance payable to the respondents is not yet dispersed. That's the one. 15. Then appears for the appellant in the morning session as well as in the afternoon session. List this matter after 2 weeks. Same all.
31, English.
The trial court has come to the conclusion that the property is granted to the defendant's father. Based on what? Original title deed in grant order is.
On the court ground that the original title deed is given is in the hands of the first party. And other grounds were that I have admitted the name of the first defendant, the father of the name of the father of the first defendant in the proceedings which have filed as against the petition proceeding. On these 2 grounds alone, my lord, the court has come to the conclusion it has been granted in favor of the father of the land has not been taken consideration in the application.
The land is vacant. Land is vacant.
No, my lord. No, my lord. I have put in the reshme shed and we're growing there, my lord.
Unmute your video, Mr. Bhagat.
Yes, my lord. It's unmuted.
You're not visible.
Yeah. Everything is on only, my lord.
You are not visible. You can do one thing.
Yes.
You can log off and reconnect.
Yes.
What you tried to say in the morning is the thumb impressions match. then this person is not the grantee because he claims that he has not sold the property. Since the property is sold, he is not the grantee. That is your contention.
But at any,
Just a second. If it does not match, then you are out.
civilian my lord, with exhibit P5 CLD,
Yes, my lord. Sorry, my lord.
in our favor.
Then what you are trying to say is the person who applied for grant and the seller are one and the same, and he is not the. Bhagat,
Yes, my lords.
again, you are not visible. See, the line of argument is like this.
Yes, my lord.
Can you hear me?
Yes, I am hearing your lordship, my lords.
See, it's like this. If the signature or the thumb impression on the application seeking grant,
Yes, my lord.
if it is thumb impression appearing on the sale deed, and if both the thumb impressions match,
Yes, my lord.
then since you have taken the contention that you have not executed the sale deed or your father has
Yes.
not executed the sale,
Yes, my lord.
the logical conclusion is the person who applied for the grant and the person who sold the property are one. Understood?
Yes, my lord. If it matches,
It doesn't match, then
Yes, ma'am.
they are saying that they are out. They will not address their argument at all.
my lords, I will take your lordship that the entire argument is that Chati Chaluvegowda and Chaluvegowda are two persons, and I am not
No,
that Chati
No,
Chaluvegowda.
forget about
Yes.
those things. No,
Yes,
forget
ma'am.
about those things.
Yes, ma'am.
Since you say that you are not the property, right? This is your consistent stand that you are not sold the property.
Yes, my lord. They are also
That
telling
event-
it's admitted fact. According to them also, and I have not sold
Sorry?
the property. According to them also, I have not sold the property.
Admitted. Yes.
Yes, madam.
Yes. If the thumb impressions match,
Yes, madam.
then it means that the person who applied is not you.
Yes, madam. Now here, my lords,
Right.
three things are
The thumb
madam.
impressions match.
Yes, madam.
Just a second. If the thumb impressions match, no,
Yes, madam.
those are all appreciation and interpretation of evidence and all because it is little bit sketchy. The different
Yes,
survey number, one survey
Yes,
number
ma'am.
mentioned in the sale deed, boundaries referring to another survey number. They're all.
Yes.
You have to analyze the evidence. You have to you connect the dot, and you have to come to a conclusion. This is a
Yes.
straightforward approach.
Yes, madam.
Since certain facts admitted. One is both the parties claim that you have not sold the property.
Yes, madam.
Right? The father has not
Yes.
sold the property. Now it is your contention that the signature appearing on the grant application is yours. Thumb impression is yours.
Thumb impression. Yes,
You are
madam.
not.
Yes, madam.
You are not disputing, right?
Yes, madam. Yes, madam.
So if that is the case, then if the thumb impressions match, then since you say that the thumb impression on the sale deed is not yours, it also goes to show that the thumb impression on the application is not yours.
Yes. My lords, where
thumb
is the
impressions
sale?
don't
No,
match.
no, important aspect, my lord.
Thumb impressions don't match.
Yes, madam.
Uh,
Important aspect here, my lord. They are not having the sale deed, not having the grant certificate.
All right.
Grant certificate I am having.
Sorry. Just a second. If the sale deed is
Yes.
not there, the
Yes,
thumb
ma'am.
impression register maintained by the sub-registrar, if it is available.
Yes, my lord. No, that they have to, my lords, they have to produce before the court. It's a
For production,
after,
it has to be summoned. For production.
no, my lords, it's under section 70, it's a public document. They can take a
So
certified
it has to be
copy
summoned.
after. Not required, my lord. They can first take the certified copy under section 74. There's a public document.
No.
And
It's
in the
like this.
appeal.
It's understood. Just a second. Certified
Yes.
copy is available, no doubt about it. But you
Yes,
can't send the certified copy for inspection.
Now, my question is, my lord, whether section 16 application in the second appeal, when there's a concurrent finding of facts is recorded.
Understood your technical point. We will go
Yes.
one step ahead. So
Yes,
what you are
ma'am.
trying to say is they must apply for the certified copy of the thumb impression register.
No,
Then they
for
must produce
trial
it.
court or appellate
And
court,
they
my lord.
must.
Fact-finding
Forget about all those-
authority. Yes, my lord.
Now, why are you so worried about the expert's opinion being
No, my lord.
secured in this case?
No, I am not. Now, I am not worried because that kind of approach shall
No,
not
let
be
us-
given
no, let-
after 18
No,
years.
let us assume. Listen,
Yes, ma'am.
listen, let us assume
Yes, ma'am.
they file an application for certified copy of the thumb impression register.
Yes, ma'am.
Obviously, the sub registrar has to issue the certificate or
Yes.
issue the certified copy, or he
Yes,
must say that it is not available, something like that.
Yes, ma'am.
If he doesn't issue the certificate, then the court has got the power to summon it.
Yes.
Right.
He
Once
has
it
to
is
give,
summoned,
madam.
once
He
it
has
is
to give. It's a public record. Yes, madam.
all right.
Yes.
He will produce the certified copy.
Yes, ma'am.
Then you will say that certified copy cannot be compared with the original signature. So it is original is required.
No, what
Then
am I?
again, see, you will issue the certified copy. You will issue the certified copy. You will take a Xerox copy of the register, certify it, and you will furnish it to the court. Then what happens? You will come out with an objection. Since it is a Xerox copy, which is later certified, the thumb impression appearing on this Xerox copy cannot be compared with the thumb impression appearing on the grant application. Then again, the court has to pass an order for summoning the thumb register.
No, madam. My entire argument is that they cannot maintain this application under section 16 in a second appeal. And support, I have filed a detailed objection for filing that application. It's not the fact-finding court. Here, what is the substantial question of law framed by them may be seen, my lord. That's very important, my lord.
If the court feels, see, if the court,
Yes.
if the court feels the additional
Yes.
evidence is required to get into the truth of the matter, there is
Yes,
no
ma'am.
objection. There is no bar.
But if they have proved that there is a substantial question of law is made out by them to admit an appeal, they cannot summon a document to get admission. First, they have to establish a fact that there's a ground for admitting an appeal. There is a substantial question of law, not a question of law or a question of fact. Substantial question of law. Supreme Court has clearly held in this regard. First, they have to establish a substantial question of law, then the question of summoning other documents. Now, these documents are admittedly not before the trial court, first appellate court. They're trying to fish it out before the appellate court.
No, what you're trying to say, no, just a second. What you're trying to say is the court exercising jurisdiction to 100 has no power to secure the document before admitting the case.
Yes, madam. They have to demonstrate the case because it's a fact.
No,
again.
are you saying this? No, are you saying this? The court has no power to secure additional document or additional evidence unless the case is admitted. Is it your case?
Yes, madam. That they have to demonstrate a case that.
All right. Which judgment you refer?
Yes, madam. Regarding.
Or we'll do one thing. We'll do one thing. We'll admit the matter.
But for admission, they have not made out a ground. That's what I'm telling you. If admission they have made out a ground, definitely I would have been considered for that application. Why? Because they have suppressed the material effect. Your lordship may seek the name of the Chalove Gowda, no Chati Chalove Gowda in the 1986 sale deed. They have conveniently suppressed that. Your lordship see these three sale deeds, my lord. I have made a detailed notes of it. My lord, boundaries in the sale deeds and name of the Chati Chalove Gowda. It's not Chati Chalove, only Chalove Gowda in the sale deed.
Whose sale deed?
That 1986 sale deed is a Chalove Gowda. Father's name Chati Venkate Gowda, son of Chalove Gowda. That may be seen, my lord.
No. Whose sale deed?
Second sale deed, my lord. 1986 sale deed, 1970 sale deed.
In whose favor?
In favor of that lady, my lord, Channaviramma.
No.
That is Chati Vaikunte Gowdara.
No. In favor of plaintiffs?
No, my lord, in favor of their vendor in predecessor vendor, my lord. For 9/4/1970 sale did be kindly seen, my lord. There also name is Chati Vaikunte Gowdara.
Just a second. Just narrate the chronology of events.
Yes, my lord. 9/4/1970, they claim that sale deed is executed by Chati Cheluvegowda. The sale deed may be kindly seen. This was completely suppressed fact. The name appearing in that sale deed.
No, just a second. Just a second. This is by Chati Cheluvegowda in favor of
Channaviramba. Not Chati Cheluvegowda, my lord. Chati Vaikunthegowdara Maga Cheluvegowda.
All right.
Their claim is that I am only Cheluvegowda, not Chati
Just a second.
Cheluvegowda.
No, just a second.
Yes,
This Cheluvegowda executed a sale deed in favor of Channavirama on 9/4/1970. Right? This is your case. Their case.
Their case also. No, their case, they are adding Chati to Cheluvegowda. There is no Chati to Cheluvegowda.
All right. What you are trying to say is Cheluvegowda executed the sale deed on 9/4/1970.
Yes, my lord.
That is in respect of survey number 149.
Survey number 89/6.
89/6. All right.
Yes.
Then what happened?
For that, boundaries may be very important, my lord. Boundaries.
Oh, okay.
In that. Purva Narendra Gaudra Jamino, Pashima Bhojappana Jamino, Uttara Sarkari Banjaru, and Dakshina Aikanahalli Elle. Aikanahalli Elle.
Yes.
Then my lord, 5777. 4D was effected. 89/1 4D was effected from 147 to 152. Survey numbers were given. For survey number 89/6, 150 was given. This is date is very important. 5777.
89/6. Yes.
Yes, it become 115/77. Now they purchased property in the year 1986.
Who?
Krishna purchases from Channaviramba. Vendors, there's a now appellant's vendor.
Channavirama purchased in sold in 1986.
1986, 1/10/1986.
To whom?
My lord, here what happened to Krishna?
Krishna.
Yeah. Yes, my lord.
So
now,
this should have been 150. No, this should have been 150.
No, it's another interesting point. Here, my lords, totally 6 properties are sold under a single 89/1, 89/2, 89/5, 89/7, 89/6, and 89/8. 6 properties under single sale deed was sold.
Except 7. Alva?
Except 7. 7 ಸೇಲ್ ಮಾಡಿದ್ದಾರೆ 89/5 3-4 ಇಲ್ಲ
3-4 ಇಲ್ಲ 7 ತೋರಿಸಿದ್ದಾರೆ. ಓಕೆ
ಹೌದು 5 6 7 8 ತೋರಿಸಿದ್ದಾರೆ.
1 2 5 6 7 8.
Yes, 5 6 7 8ಗೆ ಸಿಂಗಲ್ ಬೌಂಡ್ರಿ. For 5 6 7 8 ಸಿಂಗಲ್ ಬೌಂಡ್ರಿ. ಆ ಬೌಂಡ್ರಿ ಈ ರೀತಿ ಇದೆ ಸರ್. ಪೂರ್ವಕ್ಕೆ ಸರ್ಕಾರಿ 4 ಸರ್ವೆ ನಂಬರ್ ಸೇರಿ 14 ಎಕರೆಗೆ 14-16 ಎಕರೆ ಪೂರ್ವ ಸರ್ಕಾರಿ ಬೀಳು. ಪಶ್ಚಿಮ ಭೋಜೇಗೌಡನ ಜಮೀನು, ಉತ್ತರ ಚನ್ನವೀರಮ್ಮನ 1ನೇ ಮತ್ತು 2ನೇ ಬ್ಲಾಕ್, ದಕ್ಷಿಣ ಐಕನಹಳ್ಳಿ ಗಡಿ. This is the when this being the case, my lord, single boundary is given and 89/6 was sold. Even though there was a 4D in year 77, even after 10 years, they're selling 89/6. 4D happened in 77. Sketch is there in the 77. Then in 1994, put my boundary, purchases 149. That is my case, my lord. If it is a single boundary, single case, yes, my lord.
149 they purchase.
149 purchase. with my boundary.
Showing the boundary of 89 bar 6,
89 by 6 and 150.
No, showing the
Till
boundary of
today,
49 bar 6.
Showing the
89 bar
boundary
6.
150. 89 by 6, 150. Survey number 150.
That is same adu.
Howdo.
So in other words, they are trying to say that this 89 bar 6 was purchased twice.
89.
No, according to that, if your contention is to be accepted, it was bar 5, bar 6, and bar 7 was sold in one slot.
To Krishnappa, six properties sold in a slot.
5, 6,
Out
and
of all
7.
that, yeah, 2 properties, 1 boundary. 89 bar 1 and 2, 1 boundary. 89 bar 5, 6, 7, 8, 1 boundary.
One boundary, yes. 5, 6, 7, and 8, right? So according to them, they have purchased 89 bar 6 on 1/10/1986.
They are not purchased. Plaintiff has purchased from Krishnappa, my lord.
No, that's what I'm saying. From Krishnappa, they claim to have purchased 89 bar 6 along with other properties.
No,
5,
no
7,
other
and 8.
properties. Only one property, my lord.
See, when the boundary is shown, you yourself mentioned 4 properties are mentioned.
No, my lord. Krishnappa purchased from Chandaviramma with a single boundary.
That's what I'm saying.
Yes.
No, in that single boundary, according to you, there are 4 properties.
Yes, my lord.
5, 6, 7, and 8.
Yes. Yes, my lord.
Then
Plaintiff
you say
only one. 89 by 6 alone purchased by plaintiff.
Then later again 89 bar 6 was purchased according to them.
Yes, my lord. Plaintiff has purchased it. Yes, my lord.
So what you are trying to say
Ramesh,
is,
my lord. Plaintiff is Ramesh.
Just a second. According to you, what they are saying is this 89 bar 6 was purchased twice.
No, my lord. Krishnappa is different. Krishnappa is the vendor of the plaintiff, my lord.
All right.
Plaintiff
so
is
Krishnappa sold
Ramesh.
89 bar 6. Okay.
Yes, Ramesh purchased 89 by 6, only one property from Krishnappa.
All right.
Yes, my lord.
Then your boundary is mentioned.
My boundary is mentioned. 149, survey number 149, but my boundary.
All right.
That's what I'm telling
So
you.
140, no, just a second. 149 was never owned by Channaviramma.
Owned by lord. Owned by Channaviramma. 6 properties owned by Channaviramma.
Oh, what is owned by Channaviramma is 150 alva.
ಅಲ್ಲ 6 ಪ್ರಾಪರ್ಟೀಸ್ 47 48 49 50 50 51 52 6 ಪ್ರಾಪರ್ಟಿ. ಅದ್ರ ಹಳೆ ನಂಬರು 89 ಬರ 1 89 ಬರ 2 89 ಬರ 5 89 ಬರ 6 89 ಬರ 7 89 ಬರ 8.
Okay, all right, fine. Now 89 bar 6 according to you is 150.
Yes, my lord. That is an undisputed fact.
Undisputed fact.
Yes, my lord.
What is sold by Channaviramma is 147 actually. 148.
149.
149. 147, 148, 149, 151 and 152.
150 ಅಲ್ಲ ಅಲ್ಲಿ ಸರಿನವ್ರು 150 ಬಂದೇ ಇಲ್ಲ ಅಲ್ಲಿ. ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ರು 89 by 1, 89 by 2.
Just a second. 147, 148, 149, 151 and 152.
150 ಅಂದ್ರೆ ಅವ್ರ ಪ್ರಕಾರ 89 ಬರ್ 6 150 ಆದ್ರೆ ಅದನ್ನು ಸೇಲ್ ಆಗಿದೆ ಅದ್ರ ಡೀಟ್ ನಲ್ಲಿ. ಅಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ ಬಂದಿಲ್ಲ, 150 ಎಲ್ಲ ಬಂದಿಲ್ಲ ಅಲ್ಲಿ. 89 ಬರ್ 1 2 89 ಬರ್ 5 6 7 8 ಈ 6 ಐಟಮ್ ಸೇಲ್ ಆಗಿದೆ. ಇಲ್ಲಿ 147 ಇಶ್ಯೂನೇ ಇಲ್ಲ ಅದರಲ್ಲಿ, ಆ ಸೇಲ್ ಲೀಡ್ನಲ್ಲಿ 86 ಸೇಲ್ ಲೀಡ್ನಲ್ಲಿ. ಅವ್ರೇನ್ ಹೇಳುದು ಈಗ 86 ಅನ್ನ ನ್ಯೂ ನಂಬರ್ 150 ನನಗೆ ಮಾರಾಟ ಮಾಡಿದ್ರು ಅಂತ ಈಗ ಪ್ಲೇಂಟಿಫ್ ಕೇಸು.
ಕರೆಕ್ಟ್, ಅಂಡರ್ಸ್ಟುಡ್.
ಹೌದು, ಅದ್ರ ಮಾರಾಟ 149 ಎರಡು ಸೇಲ್ ಲೀಡ್ 149.
So 149 is not this. No, just a second. 149 87 by 89 ಅಲ್ಲಿ ಎಷ್ಟಾಗುತ್ತೆ ಅದು?
89 ಬರ್ 5 ಆಗ್ತದೆ.
5 ಆಗ್ಬೇಕಾ?
ಹೌದು. ಅದಕ್ಕೆ ನಾನು ಹೇಳ್ತೇನೆ ಒಂದೊಂದೇ ಸೇಲ್
No, just a second. 149 89 bar 5 ಆಯ್ತು.
ಹೌದು.
But sale it also says 89 bar 6 is also sold.
ಇಲ್ಲ ಒಂದೇ ಅವರಿಗೆ ಸೇಲ್ ಆಗಿ ಅವ್ರದ್ದು ಚಂದ್ರವೀರಮ್ಮ ಕೃಷ್ಣಪ್ಪನಿಗೆ ಸೇಲ್ ಮಾಡಿದ್ರೆ 89/6 ಆಲ್ಸೋ ಸೋಲ್ಡ್. ಎಸ್ ಮೇಡಮ್.
Correct. In that event, 89/6 was owned by Krishnappa, purchased by Krishnappa according to their contention.
Yes, madam. Yes, madam.
Alva?
Houdu.
So 89/6 is sold to them as wrongly mentioning it as 149 according to them.
Yes, madam. Yes, madam.
Now what you are trying to say is 149 is also a property owned by them in the sense owned by Krishnappa.
Yes, madam.
So when Krishnappa says he has sold 149, it means 140. When Krishnappa says he has sold 149,
89/5.
89/5.
Houdu.
So what you are trying to say is what is sold is 89/5.
Yes, my lord. If he is having only a right over 89/6, then your lordship is right, my lord. He is having one property, sold one property. That is one. Here he has purchased 6 properties under a single sale deed of 1986. Sold one property 149, showing us at 85/6, showing the 150 boundary.
Yes. Understood your case.
Yes, my lord.
Understood your case. What is your content? No, he owned 89/5 also. Just a second. He owned 89/5 also. 89/5 was renumbered as 149.
Yes.
So you must have purchased 149.
40. But 89%.
Yeah,
150. But in RTC, my lord, by mistake, it has been mentioned as 149. 49. 40. That is most important. For 89%.
Page 148.
This is the, sorry, 40. Actually 89. Box 6.
Correct, understood.
This is actually good. Owner. So therefore, my lord, in 1970s AD, this is the boundary and this is the survey number. Block. It has been confirmed in the body. Then 150 ಮಾಡಿದ್ದಾರೆ ಇದನ್ನ. So therefore, my lord, no dispute insofar as the boundary is concerned. There is no dispute insofar as the revenue sketch is concerned.
No. Survey number 149 was earlier 89/5. What is sold is 149.
Schedule 7 for the wrong mentioning. And wrong mentioning, but I am pointing out from the code and revenue sketch.
So this exhibit P48 is used to say that what is sold is not 149 but 158. You are saying so by referring to the boundary. Where the boundary is mentioned here?
Therefore, Rashmi can see along with exhibit P3, the revenue sketch is there. There is the block name. That block has to be into grandfather first sketch ಮಾಡ್ತಾರೆ.
My lord, just intervention, my lord.
Just a second.
Yes.
1, 2, 4, 5, 6, 7, 8.
ಇದಲ್ವಾ ನೀವು ಹೇಳೋದು ಇದು?
ಅದೇ
8 blocks ಇದೆ.
8 blocks ಇದೆ. Rashmi 6. ಹೆಬ್ಬೆಟ್ಟಿನ Chatti Chelvegoda and Helpeti Pustu are. This my lord, when doing this coding, my lord, they will keep this certificate and prepare this coding. This is the sale date 1970. This is the survey number mentioned in the sale date of 1970. Boundaries also identical with that of the certificate. 97 boundary will be there. So therefore, boundary provides over the even if there is a 149 and 150 regarding the wrong mentioning of the number.
So this you are saying that this is allotted to Chatti Chelvegoda. According to you, dependent's father is not Chatti Chelvegoda. It's Chelvegoda.
Identification.
Just a second. So Bhagat, exhibit P3 alva idu? There is one sketch appended to exhibit P3.
Yes, my lord.
Reference is made to survey number. Sorry, yes, survey number 89 and
2, 3, 4, 5, 6. Yes, my lord.
8 subdivisions are made.
Yes,
against 6. Name of Chatti Chelvegoda is mentioned.
Yes, my lord. That is helpful to me, my lords. That is helpful to
No,
me.
just a second. I'm just trying to understand.
Yes,
now, are you claiming to be same Chatti Chelvegoda mentioned in serial number 6?
Only one Chatti Chelvegoda, my lords. Why I am telling?
No, just a second. No,
yes,
just a second. Are you saying that this Chatti Chelvegoda mentioned in serial number 6 is your
father,
client's father?
Yes, my lord.
So you are also claiming under. No, you are also claiming under this document.
Yes, very important, my lord. That it perceived that. 1970, according to them, Chatti Chelvegoda sold to Chandaviramma, 70. This 40, 77, still it is given to the Chatti Chelvegoda, my lord, not to Chandaviramma. This is very important aspect, my lord. If
No,
really
this
he
is earlier
purchased
document.
77, my lord, it is.
No, this
No,
is this must have been no, this might have been obtained in 77. This is original document prepared at the time of grant.
No, my lord. That time there 150 was not there, my lord. Here I am having, what I'm telling, I'm also having here document which shows surveyor is done in 5/2/1970, allotting the 89/6 as 150. Still Chatti Chelvegoda's name is shown in 77 also.
No, you are holding a different document. You are holding a different document.
No, my lord, what I'm telling 89/6 becomes 89/150. That day also in 77, Chatti Chelvegoda's name has been shown. If really sold in 70, Chandavirama's name should have been shown to 150. That's what my argument, my lord. If 77, 89/6 become 177. Oh, sorry, 150. 77 also, that share is allotted to Chatti Chelvegoda. If really Chandavirama purchased 70, that 4 shall be given to Chandaviramma. Chandaviram's place does not find anywhere, even in the resurvey number.
Now, what I'm trying to say is, are you holding exhibit P1? Sorry, P3.
No, my lord.
Exhibit P3 alvadu. P3 the second page. Second page in P3.
Yes, my lord.
Second page in P3. This is the document prepared when the land was granted.
Yes, my lord. Yes,
so when this land was granted, 89/6 is granted to Chatti Chelvegoda.
Yes, my lord. Definitely, my lord. Yes, my lord.
Now they say that this grantee, Chatti Chelvegoda, has sold 89/6 to them through Krishna.
Chandaviramma,
then Krishna.
Yes, my lord.
Yes.
But here I am telling, nowhere in the Chandaviramma's first document 70 or in 1986 document, boundaries are given. For 4 survey number, single boundary was given. That does not tally with 1994 boundary. If single boundary, single survey number is given, your lordship is right, my lord.
No.
Added to this, in 1977,
according to you, Chatti Chelvegoda sold 6 blocks, right?
No, first only one block. Chatti Chelvegoda only one block, 89/6 in 1970, according to them. We are not sold at all. He is having granted only one block, one sold. That they are telling. then their case is that she purchased all the properties in that survey number.
No, just a second. Initially, according to the plaintiffs, Channavirama purchased 89/6.
89/6 under that sale deed, 1970 sale deed, only single property. Thereafter, she has purchased several properties. No documents are produced.
Thereafter she purchased several properties.
No documents are produced, no pleading. Then she sells in 1986 6 properties under the single sale deed. There is no links are not meted, my lord. The dots are not completed.
All right. Where is the document to show that Channavirama purchased other blocks?
No documents.
Not produced. Then
It is not their case. Only when respective is in this sketch also, the thumb impression is there. According to them, this thumb impression is the.
all right, Mr. Bhagat.
Yes,
Assuming that the second sale transaction, which is pleaded, which is claimed that in which it is claimed that Channavirama purchased the remaining 4 or 5 blocks. Assuming that there is not established.
No reference in the sale deed also. Which sale deed? Nothing.
No, just a second. Assuming that there is not established.
Yes, ma'am.
What remains is Channavirama purchased 89/6.
Yes, madam. That is as a fictitious person. What I'm telling, we are not sold.
Channavirama purchased 89/6 from a person who claims to be Chatti Chalvegowda.
Yes, my lord. Another hitch in this matter, my lord, that grant certificate may be kindly seen, my lord. Yes, my lord.
No, what I'm trying to say is,
yes, my lord.
No, 89/6 from Chalvegowda or Chatti Chalvegowda, let it be.
Yes, ma'am.
89/6 is the property sold under the registered sale deed dated 9/4/1970. Sorry.
That claim, yes.
So that's now the dispute is confined to this. So what you are trying to say is you are not the vendor so far this sale is concerned. What they are trying to say is no, you are not the owner. Our vendor was Chatti Chalvegowda. That is their contention. So ultimately it boils down to the same question.
No, another
whether the person.
Sorry. Well, grant certificate to be kindly seen, my lord. 15 years non-alienation condition is there. Nobody can sell it. Our the grant certificate produce ಮಾಡಿದ್ದಾರೆ marketing evidence ಮೇಲೆ ಅದು ನೋಡಬಹುದು.
ಎಲ್ಲಿದೆ?
Last clause ನಲ್ಲಿ grant certificate ಎಲ್ಲ clause ಇದೆ. Not to alienate.
Exhibit.
Just exhibit D1, my lord. Second page. 15 years ಪರಮಾರೆ ಮಾಡಬಾರದು ಅಂತ ಅದರಲ್ಲೇ ಬರೆದಿದ್ದಾರೆ. How anybody can
D1
D1, yes, my lord.
P1.
D1, my D1.
Is admitting the grant in my favor, my lord.
No, my lord. Grant, they are admitted. Grant is in Chalvegowda. I am having the grant certificate. There is a non-alienation clause. I have not sold.
Just a second. Where is it? Exhibit D1, huh?
Yes,
D2 is the before is the separate copy. D1 is the alleged to be the original. D1 original
ನನ್ನ ಹತ್ರ ಒಟ್ಟು ಬರ ಕೋರ್ಟ್ ಹಾಲ್ ನಲ್ಲಿ ಇಟ್ಟಿದ್ದು ಒರಿಜಿನಲ್. ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಕ್ಯಾನ್ ಸಿ ದಟ್ ಎಕ್ಸಿಬಿಟ್ D3 ನೋಡಬಹುದು ಸ್ವಾಮಿ.
Class 8 may not. Of course, class is there. I'm not disputing. Class is there, but it is not the forum, my lord. It is the authority which has to consider. And if my learned friend relying upon these conditions, then
Bhagat.
Yes, ma'am.
Exhibit D1 is not the original.
D3 original, my lord. You have taken it back, my lord. Original is my client is in the open court. He has brought that original also. I wanted to see. Because of my ill health, I could not come to open court.
original.
It is taken back. We are possessing the original.
ಯಾರು ಅವ್ರ ಹೆಸರೇನು?
My lord, his name is Kumar, my lord.
ಕುಮಾರ್ ಅಂತ ಇದ್ದಾರೆ ಅಲ್ಲಿ. ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಡಿ. Yes, now read the condition.
Last condition, condition 8 in second page. ಜಮೀನನ್ನು ವಾಸ್ತವವಾಗಿ ಆಬಾದಿಗೆ ತರುವುದು ಅಥವಾ ಸದರಿ ಜಮೀನನ್ನು ಸಾಗುವಳಿಗಾಗಿ ದನಗಳನ್ನು ಮತ್ತು ವ್ಯವಸಾಯ ಮುಟ್ಟುಗಳನ್ನು ಬಳಸುವುದು ಈ ಉದ್ದೇಶಗಳಿಗೋಸ್ಕರ ಸರ್ಕಾರದವರಿಂದಾಗಲಿ ಅಥವಾ ಪರಸ್ಪರ ಸಹಾಯ ಸಂಘಗಳಿಂದಾಗಲಿ ಜಮೀನನ್ನು ಪಡೆದವನು ಪಡೆಯಲಿಚ್ಛಿಸುವ ಸಾಲಕ್ಕೆ ಈ ಜಮೀನನ್ನು ಆಧಾರ ಮಾಡಿದ ಹೊರತು ಈ ಜಮೀನು 10 ಇದ್ದಿದ್ದನ್ನು ತೆಗೆದು 15 ವರ್ಷಗಳ ಕಾಲ ಪರಭಾರೆ ಮಾಡತಕ್ಕದ್ದಲ್ಲ.
Which clause?
Last 8 clause, page 2, 8 clause, clause 8 ಮೇಲೆ down.
ಅದೇನು ಒರಿಜಿನಲ್ ಇದೆ ಅಂತ ತಂಬಿ ಪ್ರಶ್ನೆ
ಇಲ್ಲ ಅದರಲ್ಲಿ.
One thing.
ನಾನು ಅದಕ್ಕೆ ತರಿಸಿಕೊಂಡು ನೋಡ್ಕೊಂಡು ಕನ್ಫರ್ಮ್ ಮಾಡ್ಕೊಂಡೇ ಹೇಳ್ತಾ ಇರ್ತಾರೆ. ಥಂಬ್ ಇಂಪ್ರೆಷನ್ ಅದರಲ್ಲಿ ಇಲ್ಲ.
Yes,
madam.
ಇಲ್ಲ, doesn't require thumb impression. This to be issued by the Tahsildar. No, you come to this.
It is reading upon, it's admitting that the grant is maintainable. I have sold this, I mean, my vendor.
How?
Market is within the condition of ಹೇಳ್ತಾ ಇದ್ದಾರಲ್ಲ.
No.
Is reading upon.
No, if you're trying to say that the property is sold, then the sale is impermissible.
Then let it be forfeited by the government.
The court did not wait. The court can say that the sale transaction is illegal. You are not acquired any title.
Therefore, my lord, who is the owner is important. Who is the owner? Who is the grantee? Who is the grantee? Who is the owner? What is his right? My learned friend, in spite of so many impressions is there,
Okay.
is not ready to refer this matter.
No, you filed a suit for declaration of title. So the sale deed is per se illegal.
But it has not been questioned. It is not their case. Their case is that they have not sold the property at all. I can understand.
Just a second, Mr. Bhagat.
Yes, madam.
Bhagat,
Yes,
there is a clause. The clause which says that the property should not be sold within period of 15 years.
Yes, madam.
What is the consequence of violation?
No, why I am telling my lords, if really it's a fabricated document, there was no way, because she purchased all these properties together according to them. This is a fabricated document of a stranger impersonation. I am having the records, I am continued in the possession, and this is a fabricated document within 2 to 3 years.
Ignore to the benefits of the non-granting. But assuming that if the authorities initiate the proceeding, then they can forfeit that.
The fact that the second sale deed is not produced pertaining to some other properties is of not much consequence, because the property in question is only 89/6. As far as 89/6 is concerned, a sale deed is produced.
Yes, madam.
What is the original sale deed?
No, they are not having documents also, my lord.
It has been sold in other.
No, my lord.
Just a second.
Yes.
Mr. Bhagat, in your written statement, have you disputed the execution of sale deed?
Yes, my lord.
1970 sale deed?
Yes, my lord. Fabricated.
All right.
Yes, my lord.
Just a second. Now, have you laid the foundation for production of certified copy of the sale deed in favor of your vendor's vendor?
No.
There is no dispute.
Hey, disputed. Execution of sale deed is disputed.
They keep that Chati Chalegoda, and they have not sold the property.
That's it.
They have not sold the property.
That's it.
This is the written statement. The Chanvirama Malad had sold the various extent of property to the other person. Therefore, Malad not able to produce this.
You could have laid the foundation.
The Rashma can is the written statement. There is no such dispute, Malad. Rashma can see. Paragraph 11 of the written statement.
1970, only one property, not 6, sir. There's not sufficient.
11 of the statement. They don't dispute.
But
They
read-
say that we are not sold.
So execution of sale deed is disputed. Execution of sale deed is disputed or not? So Bhagat, read the written statement where you have disputed the execution of sale deed.
Yes, my lord.
11.
Yes, my lord. Yeah. Para number 1, my lord.
94 sale deed, huh?
94
ಅದನ್ನೇ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿ ಪ್ಯಾರಾ ನಂಬರ್ 1 ರಲ್ಲಿ
70 ಡಿನೈ ಮಾಡೋದಿಲ್ಲ.
ಅಲ್ಲ
ಪ್ಲೇಂಟಿಫ್
70 ಸೈಡ್ ಎಲ್ಲಿ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿದ್ದೀರಾ?
ಎಸ್ ಅದನ್ನು ಮಾಡಿದ್ದೀವಿ ಸರ್.
70 ಸೈಡ್
ಪ್ಯಾರಾ ನಂಬರ್ 3 ನಲ್ಲಿ ಸರ್. Ever that a plaint that the Chanduvirama has sold the some property bearing surrender number 89/12358 2 on the
No, averment relating to sale deed by Chatti Chilvegowda, where is disputed?
for 3, my lords. Para 3.
Para 3 na?
86 ಮಾಡ್ತಾರೆ ಬಿಟ್ಟು 72 ಮಾಡೋದಿಲ್ಲ.
Para number 2 ದಲ್ಲಿ ಮಾಡಿದಾರಲ್ಲ. Para 2. Not para 3, para
3 ನಲ್ಲಿ
not 3,
ಚಂದುವೀರಮ್ಮ.
just 2.
2 ನಲ್ಲಿ ಚೆಲುವೇಗೌಡ, 3 ನಲ್ಲಿ ಚಂದುವೀರಮ್ಮ. Yes, sir.
It belongs to government and Chatti Chilvegowda. Has applied for application to the website authority. Grant crucial property. This Chatti Chilvegowda a related person and he has to pay first the impression for the application form land certificate is finished. Later on the said Chatti Chilvegowda sold his crucial property in favor of Arrears false and rest of the allegation based on same parallel is here with it and strictly to basic. Here minute copy minute secondary evidence minute the thumb impression is out available. It is like
How can you when this see your basis for title itself is disputed by them. You have not produced the original. You have not laid the foundation for secondary evidence. Then
submission matter. Both of them, my vendors filter as well as the father. The application.
so see no, it is simple. 149 you have purchased. 149 is with you. Now how you account for now how you account for this production of original grant order by defendant? No. Where is the evidence? Not the argument. Where is the evidence?
No evidence.
Evidence argument that's not understood.
Of the education of his father. Then once he pretends that if these teachers are produced by me, that they studied and knew signature as Chilvegowda.
No. The question is how you can account for production of original grant order in the name of in the hands of defendant under the based on evidence, not on logical argument.
All these sketches were produced by the revenue sketch and other things.
So those things are certified copies. Anybody can obtain and produce it. Once you produce it, he need not produce it. No. Once you
corroborating the availability of the individual matter.
No, he says he's the grantee. See,
It was written the other data 96, right? Still is that. Whereas Chatterjee wrote in Homo. It was 1950. If
Mr. Bhagat, Bhagat,
Yes, madam.
what is your explanation to the age shown in the application seeking grant? You claim to be age 50.
Yes, madam.
What is your explanation?
Madam, I specifically stated that what was my age during cross-examination. I specifically asked whether any other person is there in the. He told no, I don't know. That evidence may be kindly seen, madam. Cross-examination.
Understood. That is understood.
Yes.
How do you say that you are aged 20, 50? Huh? How you say that your age is 50 when you file application?
That may be mistake, madam. That may be mistake.
No, all right. Whether any discussion by the trial court and the first appellate court on this document relating to age?
Age. They have not taken this contention. Well, cross-examination, they have asked that. And they have not taken any contention of that regard. Because during cross-examination, he failed to answer. 1 minute, my lord. Two things, my lord. One.
Just a second. Just a second.
Yes.
Contention.
Evidence in law. Plaintiff has not stepped into the witness box. His GPA holder is examined. He's called a distant cousin.
ಪ್ರತಿವಾದಿಯ ತಂದೆ ಚೆನ್ನವೇಗೌಡ ಅವರನ್ನು ಡಿಪ್ಯೂಟೆಡ್ ವಿದ್ಯಾವಂತನಾಗಿದ್ದು ಅಂತಾರಾಷ್ಟ್ರೀಯ ಸರ್ಕಾರಿ ಕಾಲೇಜಿನಲ್ಲಿ ಇವತ್ತು ಆತ ಮೂಲ ಮಂಜೂರಿದ್ದಾರೆ ಅಲ್ಲ. ಒಂದು ವೇಳೆ ಆತನ ಮಂಜೂರಿತನಾಗಿದ್ದರೆ ಮಾಡುತ್ತಿರಲಿಲ್ಲ. ಅಲ್ಲದೆ ಆತನ ದಿನಾಂಕ 25/9/45 ಮೂಲ ಮಂಜೂರಿದಾರ ಚೆನ್ನವೇಗೌಡ 35 ಅರ್ಜಿ ನೀಡಿದಾಗ ಅಹವಾಲು ತಕ್ಕಂತೆ ತನ್ನ ವಯಸ್ಸನ್ನು 50 ವರ್ಷ ಎಂದು.
Yes, Bhagat.
Yes,
Mr. Bhagat.
Yes.
Plain paragraph 5. There is a specific contention.
Yes, ma'am.
That Chatti Gowda was educated person. And his age, he was born on 25/9/45. And in the application seeking grant, his age is mentioned as 50. So that person did not apply for the grant. That is their contention.
Yes, madam. Here they have produced, I told the documents, school records produced a fabricated document in cross-examination specifically countered it. Specifically countered. That is their case.
Which is fabricated according to you?
All the documents.
According to which is fabricated?
According to them, there are 10 Chaluvegowdas, son of Venkatagowda in the. There is a cross-examination is recorded, madam. There are 10 Chaluvegowdas. Yes, madam.
Now, which document is fabricated?
Those are all school records, etc. produced. They specifically cross-examined him. Then they tell, I don't know that there are 10 Chaluvegowdas in that particular village. And I told, for this case, you have fabricated this document. Author of the document is not examined.
So which document is to be?
The cross-examination
is to be proved.
Yes,
which document is to be proved by examining the author?
Saying that documents are belonging to me, school records, etc., belonging to me. Apart from producing the same, there is no other evidence.
Did they produce this TC or something like that?
Yes, madam. I told it's not belonging to me.
Which TC? Exhibit?
Yes, madam. Their cross-examination will be highlighted in 3-4 questions of cross-examination. Very important. It will throw the light on the entire their effort.
All right.
Cross-examination of PW1. Who is he, madam? That's very important. At page 7, PW1, page 7. ನಾನು 10ನೇ ತರಗತಿಯವರೆಗೆ ಓದಿದ್ದೇನೆ. ಫಸ್ಟ್ ಐ ವಾಂಟ್ ಟು ಎಸ್ಟಾಬ್ಲಿಷ್ ಹೂ ಈಸ್ ಹಿ. ವಾದಿಯು ನನ್ನ ತಮ್ಮ ಆಗಿದ್ದಾನೆ. ಫಸ್ಟ್ ಈ ಸೇಸ್ ಈಸ್ ತಮ್ಮ. ದೆನ್ ವಾದಿಯು ಯಾವುದೇ ನೌಕರಿಯಲ್ಲಿ ಇರುವುದಿಲ್ಲ. ವಾದಿಗೆ ಯಾವುದೇ ಅನಾರೋಗ್ಯ ಇರುವುದಿಲ್ಲ. ಈಗ ಹೇಳ್ತೀನಿ, ವಾದಿಯು ನನ್ನ ಚಿಕ್ಕಪ್ಪನ ಮಗ ಆಗಿದ್ದಾನೆ. That's very important. Plaintiff who is
see in common parlance, he will be called as Tamma. Really.
Yes, no, but it is misled everywhere. In his GP also it has been misled. And he has not stepped into it, withholding the best evidence. He would have been have the knowledge of this thing.
Knowledge relating to what? Knowledge relating to what?
It's all documents, my lord.
No, how? He has purchased the property somewhere in 94.
No, my lord, documents of my father, my lord. They are telling my father's document produced by the plaintiff. GPA holder examines himself. Plaintiff is not
So
examined.
he is producing GPA holder is giving evidence based on the public records.
No, my lord, that knowledge must be with the plaintiff. Pleading is by the plaintiff. Pleading signed by the plaintiff. Ramesh signed the pleading. Yes, ma'am. That's one.
All right.
Next parameter. Next page 8. ಸರ್ವೆ ನಂಬರ್ 150 ಒಬ್ಬ ವ್ಯಕ್ತಿಗೆ ಮಾತ್ರ ಮಂಜೂರು ಆಗಿದೆ. ಇಂಪಾರ್ಟೆಂಟ್ ಥಿಂಗ್ ಮಗ. ವಾದಿಗೆ ಒಬ್ಬ ಸ್ವಂತ ಸಹೋದರ ಇದ್ದಾರೆ. ವಾದಿ ಮತ್ತು ಆತನ ಸಹೋದರ ವಾಸವಾಗಿ ಇದ್ದಾರೆ. ಮೊದಲಿಗೆ ಸರ್ವೆ ನಂಬರ್ 150 ಆಸ್ತಿ ಸರ್ಕಾರಿ ಜಮೀನಾಗಿತ್ತು. ಸರ್ವೆ ನಂಬರ್ 150 ಚಾಟಿ ಚಳುವಳಿಗೆ ಮಾತ್ರ ಜಮೀನು ಮಂಜೂರಾಗಿತ್ತು. This is the exam. Then I will take on next page 9. This is very important, my lord. 14
So it is their case that the property is granted to Chatti Chelvegowda, right?
Yes, my lord. But that is falsified by their sale deed of 1970, which says Chelvegowda. That is an important thing, my lord. Sale deed only it says Chelvegowda.
Are you saying that property is granted to a person by name Chelvegowda?
Chatti Chelvegowda, he is my father. What is sold by a Chelvegowda is a fabricator, impersonator.
All right.
Yes, ma'am.
See, are you saying that they have got a sale deed, right?
In the name of Chelvegowda. Their argument is entire thing is Chatti Chelvegowda sold. That exhibit may be kindly seen, but just I did that exhibit.
No, understood. They have referred to word Chatti by referring to the father's name.
Yes, my lord.
So probably they might have omitted.
No,
see, there's
there must be their entire case is that Chatti Chelvegowda was granted the land. I am not the Chatti Chelvegowda. There is no contrary evidence adduced before both the courts below.
All right. What is the finding of the trial court and the first appellate court on the contention that Chelvegowda or Chatti Chelvegowda was literate and he would not have put the thumb impression and his age is shown to be 50 on the grant application? What is the finding of the trial court and first appellate on this contention?
Yes, ma'am. I will take a lordship to that, ma'am. At para 11, my lord. Internal page 55 of the paper book.
Paper book ಹಾಕಿದ್ದೀರಾ ಅದು?
ಅಲ್ಲ ಯಾವುದು original paper book.
All right.
Yes, ma'am. Para 10, ma'am. I will start from para 10. We're having a discussion on that, ma'am. The plaintiff, in order to show the acquisition of right interest possession of the scheduled property, placed the reliance on the original grant made in favor of one Chatti Chelvegowda. As a part of the evidence, I will skip that, my lord. Now, next page, 49. So, on facts, the original grant certificate standing in the name of the Chatti Chelvegowda is in the custody of the defendant, number 1, who claims to be the son of original grantee. As per the defendant number 1, name found in exhibit D1, namely Chatti Chelvegowda, is none other than his father, and the property of his father mutated in his name. Rather, no alienation taken place by his father in the favor of any person, any one else. Per contrast, it is a case of the plaintiff that father of the defendant is only called as Chelvegowda and not Chatti Chelvegowda found in the grant certificate is none other than the father of the defendant number 1, and the said grantee is altogether different person. Well, that case is a different person. Where is that different person?
So that is what they are trying to say. See,
No,
what they are
he
trying to
was
say
there, my
is,
lord. Physical establishment of that person is required. I specifically cross-examined, where is that person?
they are not purchased the property from the Chatti Chelvegowda. They are successive purchasers.
No, what I'm telling, my lord, when they are established, this what entire case is there, their vendors is having no right. That is the claim taken by issues were claimed, my lord. Whether their vendors are having a right to sell the property, answered in negative. Issue has been a specific issue in that regard, my lord. And just read out that issue, my lord. That's very important, my lord. It's not just strangely they have taken this case. My lord, that issue may be kindly seen, my lord. Whether the plaintiff proves that his vendor had a saleable interest.
Just a second. Just a second, Bhagat.
Yes, my lord.
If on appreciation of evidence, the court comes to the conclusion that the property in question is not allotted to the defendant's father, based on appreciation of evidence in the backdrop of contention that he was aged 50 when this application was filed, and he was literate and he could have signed. What is the consequence?
No, he specifically told, I will later learn to sign under Vayaskara Shikshan. There is a pleading evidence. Now, what the hebat hakta is the specific pleading is there. Hebat hakta is there. Nantra,
that's why I'm asking how the trial court and the first appellate court has dealt on this contention.
Yes,
that's my question.
Okay. Yes, madam.
If they have answered to this contention, that's fine.
Yes, madam.
See, there is a specific para in plaint on the basis of which they have filed this case.
Yes,
there has to be an answer in the judgment of the first appellate court and trial court.
Yes, madam. Regarding saleable interest, I have shown, my lord. Now, my lord. Now, issue, my lord. Issue regarding. Whether the plaintiff proves that he has acquired the associative property as a contained in para number 1 of the plaintiff, that is inconsequential, my lord. Second issue is very important, my lord. Whether the plaintiff proves that his vendor had a saleable interest over the associative property as contained in para number 2 and 3 of the plaintiff. Now, associative property will be kindly seen, my lord. They are telling associative property 150. From 77, it is 149 and 150. Without rectification from last 86 years, from 86 onwards, can they claim without seeking for the relief of rectification of the sale deed? That is the basis on which they are claiming right over the associative property. Associative property is not 149. That is not their pleading that survey number boundaries are same, survey number is changed, and survey number is changed in the RTC, not in the sale deed. It is not their case, my lord. Therefore, both the courts below have held, you are not the owner of the associative property based on your sale deed. Sale deed is pertaining to 149. If they have been sought for rectification of the sale
just a second. Have you averred in the plaint that the survey number 149, 150 is wrongly described as survey number 149 in the plaint?
No. They tell in RTC mistake happened. Para number 3 of the plaint, my lord. Para 3 of the plaint. ಶ್ರೀಮತಿ ಚೆನ್ನವೀರಮ್ಮನ್ ಅವರ ಸರ್ವೆ ನಂಬರ್ ನಲ್ಲಿ 89ರಲ್ಲಿ ಕೋಡ್ ನಂಬರ್ 1ರಿಂದ 3 ಹಾಗೂ 5ರಿಂದ
ಕಂಟೆನ್ಷನ್ ಇದೆ ಅಲ್ಲ
ಅಲ್ಲ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ತಪ್ಪಾಗಿದೆ ಅಂತ ಹೇಳ್ತಾ ಇಲ್ಲ ಅವರು RTC ಅಲ್ಲಿ ಅದು ದಟ್ ಇಸ್ ರಾಂಗ್.
See, you read this paragraph in its entirety.
Yes, my lord.
They also refer to the boundary.
RTC ಅಲ್ಲಿ ತಪ್ಪೇ ಆಗಿಲ್ಲ. RTC ಅಲ್ಲಿ ಕರೆಕ್ಟ್ 140 105 ಎಲ್ಲ RTC ಕರೆಕ್ಟ್ ಇದೆ. ಇವತ್ತು ಇದೆ.
See, what you have to understand is survey number 150 which they have purchased is wrongly shown as 149 in RTC. ಹಿಂಗ್ ಹೇಳೋದವರು
ಅಲ್ಲ ಸೇಲ್ ಡೀಡ್ ನಲ್ಲಿ ದುಡ್ಡು ಬರ್ಬೇಕಲ್ಲ ಸ್ವಾಮಿ. ಸೇಲ್ ಡೀಡ್ ನಲ್ಲಿ ತಗೊಂಡಿದ್ದು 149 86 ನಲ್ಲಿ
See, you have to go by the essence of what has been pleaded in para number 3.
No,
Para number 3, there is a contention.
ಅಲ್ಲ ಅವ್ರು ಸೇಲ್ ಹಿಡಿದ್ರೆ ತಪ್ಪು ಅಂತ ಇಲ್ಲ. 86 ಸೇಲ್ ಹಿಡಿದಲ್ಲಿ ಏನ್ ಸ್ವಾಮಿ, ಅದ್ರಲ್ಲಿ 149 ತಪ್ಪಾಗಿತ್ತ ಅದ್ರಲ್ಲಿ? ದಟ್ ಇಸ್ ನಾಟ್ ದರ್ ಕೇಸ್.
See, what they are trying to say is boundary shown in 89 sale deed, boundary shown in other sale deeds, and boundary shown in this sale deed all pertain to survey number 150.
ಇಲ್ಲ, ಅದು ಎಲ್ಲೂ ಇಲ್ಲ. ಸದ್ಯ ಚಕ್ಕ ಬಂದಿ ಸರ್ವೆ ನಂಬರ್ಗೆ ಹೊಂದಾಣಿಕೆ ಆಗುತ್ತಿದೆ ಅಲ್ಲದೆ ಜಂಟಿ ಸಂಬಂಧಿತ ಎಲ್ಲ ದಾಖಲೆ ಹಿಂದಿನ ಸರ್ವೆ ನಂಬರ್ಗೆ ತಾಳೆ ಆಗುತ್ತದೆ 86/60ಗೆ. ಅದು ಎಲ್ಲಿ ತಾಳೆ ಆಗ್ತದೆ ಸರ್? 86 ನ ಸರ್ವೆ ನಂಬರ್ ಬೌಂಡ್ರಿನೇ ಇಲ್ಲ. ಕಾಮನ್ ಬೌಂಡ್ರಿ 86 ನಲ್ಲಿ, ಅಲ್ಲೇನಾದ್ರು ಬೌಂಡ್ರಿ ಇದ್ದಿದ್ರೆ ಬೇರೆ. 1970 ನಲ್ಲಿರೋ ಬೌಂಡ್ರಿ ಬೇರೆ. It may be seen by 1970 boundary. That is regarding 89/6. ಬೇರೆನೇ ಇದೆ ಬೌಂಡ್ರಿ.
Para number 6 ಗೆ ಹೇಳಿದ್ದಾರೆ. So other owners are also made parties.
ಯಾರು ಮಾಡಿಲ್ಲ. ಒರಿಜಿನಲ್ ಖಾಲಿ ಕೃಷ್ಣಪ್ಪನಿಗೆ ಮಾತ್ರ ಪಾರ್ಟಿ ಮಾಡಿದ್ದಾರೆ, ಮತ್ತೆ ಯಾರು ಇಲ್ಲ. ನನಗೆ ಕೃಷ್ಣಪ್ಪನಿಗೆ ಮತ್ತೆ ಯಾರು ಇಲ್ಲ ಅಲ್ಲಿ ಪಾರ್ಟಿ
ಮಾಡಿ. ಪ್ಲೇನ್ ಟರ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ 6.
ಯಾರು ಇಲ್ಲ, ಕೃಷ್ಣಪ್ಪ ಮಾತ್ರ.
ಅವರು ಅಗತ್ಯ ಪಕ್ಷಗಾರ ಇರುವುದನ್ನು ಹೇಳಿದ್ದಾರೆ.
Collusive suit it is.
ಮೂರು 5 7 8. All right, now show the finding of the first court on issue number 2. That is relating to para number 2 and 3.
Yes,
Where is the
yes, issue number 2. I'll take a lordship petition for trial court.
1 to 3 general authority.
Yes, my lord. Para number 9. I will leave that para number 8, my lord. Para number 9 to 845. As per the plaintiff, suit schedule property bearing old survey number 89/6 originally belongs to the government, and once Sri Chati Cheluvegowda son of Poikutagad had applied for the grant of certain extent of land out of the said land property as on 14/9/1965, which came to be entered by the issuance of grant certificate 23 to 2017 for of said Chati Cheluvegowda, who later, as per the sale deed dated 9/4/1970, namely as per exhibit P5, sold the property described in the plain schedule in favor of the Channaviramma, who later alienated the said property in favor of second dependent and his brother late Vishwanatha as per sale deed dated 1/10/1983 as per exhibit P6, and it is the said second dependent and his brother further alienated the property mentioned in the scheduled property in favor of plaintiff as on 31/1/1994 as per exhibit P8. Thereby he has in possession enjoyment of the suit schedule property. Per contra, whereas suit schedule property is 150, that will be noticed better. 149 is in the sale deed at exhibit P8. And thereby he is in possession enjoyment of suit schedule property. Per contra, the defendant was specifically contained that suit schedule property is bearing survey number 89/6 originally granted in favor of his father Chati Cheluvegowda, son of Vaikunthegowda, and was in possession and enjoyment of the same, and thereafter the said father of the defendant number 1 consented for the change of khata in favor of the said defendant number 1, who by change of khata in his favor as per MR number 38/9394 got mutated his name in the RTC and raised loan over the said property for improvement, and he is in possession and enjoyment of the same. So as a specific case of the plaintiff, the defendant number 1 stands the very plaintiff tracing his title, interest as well as possession over the suit schedule property through his vendor and through the previous vendors of the said defendant number 2 and his brother claim right, interest and possession over the scheduled property. On the other hand, defendant number 1 claiming that suit schedule property was granted in favor of his father asserts his possession and enjoyment over the suit schedule by showing the same in the written statement scheduled by way of the mutation in his favor by consent of his father. Is alleged by the plaintiff against the defendant number 1 the name of the father of the first dependent only Cheluvegowda. So Vaikunthegowda rather than said defendant number 1 taking advantage of the name of his father as a Cheluvegowda in collusion with the revenue officials.
Just a second. You are not examined any person to show that there was a person by name Chati Cheluvegowda designed by the trial court. Now, unless you are able to establish that there existed a person by name Chati Cheluvegowda,
was the purpose of the Marathi is the least commercial document. And 1970 document is also in the circumstances where the identification purpose. The thumb impression is there. And the only indicator which can prove who is the grant. I don't know why because father is still alive. Why is supposing?
Yes, my lord.
He is supposing.
Your father is alive?
Yes, but 81 years, he is still alive. My lord. Bedridden, he was hospitalized in Bangalore, now shifted to Chandrayapatna. Sorry, in Carpet.
No, just a second. Stating that it is an application filed by you seeking grant. You admit that?
Yes, my lord.
The application produced by them, produced seeking grant. You admit that?
Yes, my lord. We have filed the application, but that's our consistent stand, my lord.
All right. No, that application which is placed before the court, which purports to be contains your thumb impression.
Yes, my lord.
Is it the application filed by you?
Yes, my lord. I have filed that application. Based on that, as per D3, grant was made, my lord.
Now, where is the finding of the first appellate court on the contention that he was aged 50 and he was literate? Where is the finding?
My lord, he was not the party to the suit. First of all, he is not made a party to the suit.
No, finding of the trial court and the first appellate court on the contentions raised in para number 2.
Yes, madam.
The issue is relating to para number 2 and 3.
Yes, madam. The court has arrived at a conclusion, para 11, my lord.
Basically, the court has come to the conclusion based on the production of original grant order. That
Not
seems to be
the cross examination. He says, ಯಾರು ಪಡೆದುಕೊಂಡು ನನ್ಗೆ ಗೊತ್ತಿಲ್ಲ, ಚನ್ನವೀರ ಮೂಲತಃ ಯಾವ ನನ್ಗೆ ಗೊತ್ತಿಲ್ಲ, ಚಾಟಿಗಳ ಚಳುವಳಿಗಳನ್ನು ನಾನು ನೋಡಿಲ್ಲ. Then only ಚಾಟಿ ಚಳುವಳಿಗಳು available is the defendant's father. When the absence of another ಚಾಟಿ ಚಳುವಳಿಗೌಡ, they cannot deny. That is the finding of the appellate court.
No. In the cross examination, you yourself have suggested that there are many 8 or 10 chatti chalegaudas.
No, he has suggested. I am telling there is no chatti chalegauda apart from father. He says no, 10 are there. He says. PW1 says. In
that event, no, all right. In that event, why this school record should be disbelieved?
But he has specifically not belonging to me. Then he has not.
So you said there are no other persons.
Yes, my lord. I am not gone to school. I only ವಯಸ್ಕರ ಶಿಕ್ಷಣ ಮಾಡಿದ. There is specific cross examination ಎಲಿಸಿಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ನಮ್ಮ ತಂದೆ ಸ್ಕೂಲಿಗೆ ಹೋಗಿಲ್ಲ, ವಯಸ್ಕರ ಶಿಕ್ಷಣದಲ್ಲಿ ಕಲ್ತಿದಾರಂತೆ, ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಎಲಿಸಿಟ್ ಇದೆ.
No, just a second. Which is their school record they have produced? PC?
P12. P43 is the signature notice. Admitted
P12 is ಇದು ವ್ಯಾಸಂಗ ಪತ್ರ ಅಷ್ಟೇ. It is not TC. ಯಾವ್ದು which signature ನೋಡ್ಬೇಕು?
43.
What is that?
Client ಅವರೇ. Chillegowda, alias Chatti Chillegowda, ex-wife. The painting company is teacher Chillegowda at page 3. And the signature is teacher, as it is still good.
What is the finding of the trial court and the first appellate court on this document?
ಯಾಕಂದ್ರೆ ಇಲ್ಲ ಎಕ್ಸಿಸ್ಟೆನ್ಸ್ ಇಲ್ಲ ಅಂತ ಇವ್ರ ಎಕ್ಸಿಸ್ಟೆನ್ಸ್ ಎಲ್ಲ ಇಲ್ಲ ಅಂತ ತಗೊಂಡಿದ್ ಕಾರಣ ಇದಕ್ಕೆಲ್ಲ ಹೋಗಲ್ಲ.
There is no discussion.
On the fail to establish one person is there, then the question of answering that they fail to bring that somebody, some another Chati Gowda is there. That is the finding of both the courts below. Mattab Chati Gowda is avanu namaga sale ಮಾಡಿದ್ರು ಅಂತ ತಕೊಂಡು ಬಂದಾಗ the entire issue will come. They fail to establish
No,
existence of another Chati Gowda.
No, that can be established if the thumb impression on the grant agreement is compared with the thumb impression before the sub-registrar.
No, there ಈಗ ಒಂದು ಊರಿನಲ್ಲಿ ಚಾಲಿ ಚೌಡಿಗೌಡ ಇದ್ದ ಅಂದ್ರೆ ಅವ್ರ ಮಗ ಮೊಮ್ಮಗ ಯಾರಾದ್ರೂ ಇರ್ಬೇಕು, ಹೆಂಡತಿ ಮಕ್ಕಳು, ಅವ್ರ ಯಾರ ಮಗ ಅವನು ಅಂತ ಹೇಳಿ. ನಮ್ಮಪ್ಪ ಸೇಮು, ನಮ್ಮ ಅಪ್ಪನಿಗೆ ನಂಗೆ ಅಣ್ಣ ತಮ್ಮಂದಿರಿದ್ರೆ ನಾನು ಒಬ್ಬನೇ ಇರೋದು, ಮತ್ತೆ ಯಾರು ನಮ್ಮ ಅಪ್ಪನಿಗೆ ಮಕ್ಕಳು? ವೆಂಕಟೇಗೌಡ ಇರೋದು, ವೆಂಕಟೇಗೌಡ ಮತ್ತೊಬ್ಬ ಇದ್ದಾನೆ, ಆ ವೆಂಕಟೇಗೌಡ ಚಾಟಿಗೌಡ ಮತ್ತೊಬ್ಬ ಇದ್ದಾನೆ. ಅಪ್ಪನಿಗೂ ಸೃಷ್ಟಿ ಮಾಡ್ಬೇಕು, ಅವಾಗ ನನ್ನ ಅಪ್ಪನಿಗೂ ಸೃಷ್ಟಿ ಮಾಡ್ಬೇಕು. ಚಾಟಿ ಚಳುವೇಗೌಡನಿಗೆ ಅಷ್ಟೇ ಅಲ್ಲ, ನಮ್ಮ ಅಪ್ಪನಿಗೂ ಸೃಷ್ಟಿ ಮಾಡ್ಬೇಕು.
What evidence you have led to show that none of us agree? Apart from 20 who is examined? ಮಾಡಿಲ್ವಾ?
ಮೂರು ಜನರಿಗೆ ಮಾಡಿದ್ದಾರೆ. ಒಬ್ಬ ಸ್ಕ್ರೈಬ್, ಒಬ್ಬ ಗ್ರಾಮ ಲೆಕ್ಕಿಗ, ಮತ್ತೊಬ್ಬರ ಸೆಲ್ಲರ್ ಕೃಷ್ಣಪ್ಪ.
Page number 10. Page number 10. That is why not speaking to page number 10.
Yes.
Suggestion. Therefore, the question of
According to you, dependent is only Chervegowda. Dependent is Chervegowda. Dependent's father Chervegowda.
and he has stayed in exhibit. Chervegowda, not Chervegowda. What is the question?
Bhagat,
Yes,
where is the finding of the trial court on the contention relating to para number 2 and 3?
they have come arrived at both the courts have stated he failed to answer the existence of another Chaluvegowda or Chati Chaluvegowda. Therefore, question of giving finding does not. In that way, they have come. There is no evidence on the record to say that another Chati Chaluvegowda born to Venkategowda was there. So he is a person impersonator. There is no evidence. And during the cross-examination of PW1 may be kindly seen by a very interesting cross-examination. Specifically asked him this question. Page 10. Page 10 of his cross-examination of PW1. ನಾನು ಹೇಳುತ್ತಾ ಇರುವ ಮತ್ತೊಬ್ಬ ಚಾಟಿ ಚೆಲುವೇಗೌಡರು ಮರಣ ಹೊಂದಿರುವ ಬಗ್ಗೆ ಪ್ರಮಾಣ ಪತ್ರ ಕೊಟ್ಟಿಲ್ಲ. ಅಕಾರ್ಡಿಂಗ್ ಟು ಮಿ ಡೈಡ್. ಆದರೆ ಇತರ ಎಲ್ಲ ದಾಖಲೆಗಳನ್ನು ಹಾಜರು ಮಾಡಿದ್ದೇನೆ. ಒಂದನೇ ಪ್ರತಿವಾದಿ ಮತ್ತು ಆತನ ತಂದೆಯ ಸ್ವಾಧೀನದಲ್ಲಿ ಇರುವ ಕಾರಣದಿಂದ ನಾನು ಈ ದಾವೆಯನ್ನು ಮಾಡಿದ್ದೇನೆ. ಅವರು ನನಗೆ ತೊಂದರೆ ಕೊಟ್ಟ ಕಾರಣದಿಂದ ಈ ದಾವೆ ಮಾಡಲಾಗಿದೆ. ದೆನ್ ಆಫ್ಟರ್ ಒನ್ ಪ್ಯಾರಾಗ್ರಾಫ್ my lord, ಚಿಕ್ಕತಾರಹಳ್ಳಿ ಗ್ರಾಮದಲ್ಲಿ ವೈಕುಂಠೇಗೌಡನ ಮಗ ಚಾಟಿ ಚೆಲುವೇಗೌಡ ಎಂಬ ಹೆಸರಿನ ಮತ್ತೊಬ್ಬ ಬೇರೆ ವ್ಯಕ್ತಿ ಇದ್ದರು ಎಂದು ತೋರಿಸಲು ಮತದಾರರ ಪಟ್ಟಿಯನ್ನು ಹಾಜರುಪಡಿಸಿದ್ದೇನೋ. ಹೇಗೆ ಎಂದರೆ ಆ ವ್ಯಕ್ತಿಯು ಬಹಳ ಹಿಂದೆ ಮರಣ ಹೊಂದಿದ್ದಾರೆ ಮತ್ತು ಆ ಕಾರಣದಿಂದ ಹಾಜರು ಮಾಡಿಲ್ಲ. ನಾನು ಹೇಳುತ್ತಾ ಇರೋ ಮತ್ತೊಬ್ಬ ಚಾಟಿಗೌಡನ್ನು ನಾನು ನೋಡಿರುವುದಿಲ್ಲ. Then what evidence is required? He has to establish another is there. If he establishes that another is there, then I have to prove it. I am only Chaligauda. If two persons are there, then I have to establish that the name shown in the grant certificate is me only. Another person is not there, no evidence.
The name voted the 54. The serial number 54.
ಯಾರು voter list ಅದು?
Entire village.
ಅಲ್ಲ, whose name is there? ಅಲ್ಲ, which Chelvegoda? Your vendor or his?
Protest of 1983. So can you come to serial number 252? Devama.
62.
62. Devama. Chelvegoda. Father Chelvegoda. Father.
So what you are trying to say is he is not Chatti Chelvegoda. What is the finding of the first appellate court trial court on this?
My lords, how they have admitted my father's name is Chatti Chelvegoda. Exhibit P10 may be seen, my lord. Exhibit P10 is a government record filed by them. Appeal. Exhibit P10. That is their case. They filed the case before the authority. My name has been shown as Kumara bin Chatti Chelvegoda. Exhibit P10 filed by them and produced by them. Exhibit P10 marked in evidence. During cross-examination, he admitted it. Yes, I have mentioned as Chatti Chelvegoda, father's name. What else is required, my lord? It's admission. Exhibit P10 filed by them. Case filed by them. My father's name is Chatti Chelvegoda. Exhibit P10. Cross-examination, he admits it. My lords, this is proceeding initiated way before.
Why from the first time? Until then, it is still not Chelvegoda. ಆಮೇಲೆ ತಮಗೆ ಇಷ್ಟೆಲ್ಲ ತಮಗೆ ಪ್ರಶ್ನೆ ಏನು ಕೊಡ್ತಾರೆ ನನ್ನಂತೂ ಗೊತ್ತಾಗ್ತಾರೆ. He said it's application. He said it's communication. Why not? I'm agreeable.
My lords, they cannot fish out something in the appeal when they lost in 6 courts. That is not permissible. It's a question of fact. All the revenue courts, civil courts have concurrently held. There is an admission. My father is Chatti Gowda.
See, Mr. Bhagat.
Yes, madam.
Para number 2 and 3 contention is very specific.
Yes, madam.
That age of the person who applied for grant was 50. He could not have put the thumb impression on the application. So based on that, they are trying to make out a case that defendant's father was not the applicant. There is no adequate discussion on. There is no adequate.
In the evidence,
first appellate court, trial court.
Both have stated.
Trial court has not
evidence. Based on my evidence, I specifically stated, my lord. I specifically stated here, my lord, my cross-examination, what they have elicited will be kindly seen, my lord. At page 4 of my cross-examination, just I will read out, my lord. Namma gramadalli Chatti Chelvegoda endare namma tande obbare. ನನ್ನ ತಂದೆಯ ಹೆಸರು ಕೇವಲ ಚಾಟಿ ಚೆಲುವೇಗೌಡ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಾನು 1983 ಚುನಾವಣೆಯಲ್ಲಿ ಮತ ಚಲಾಯಿಸಿದ ಏನು ನನ್ನ ಜ್ಞಾಪಕ ಇಲ್ಲ. ಪಾರ್ವತಮ್ಮ ಕೊಂಬ ಚೆಲುವೇಗೌಡ ನನ್ನ ತಾಯಿ ಎಂದರೆ ನನ್ನ ತಾಯಿ ಹೆಸರು ಚಾಟಿ ಚೆಲುವೇಗೌಡ ಎಂದು ಸಾಕ್ಷಿ ನೀಡುತ್ತಾರೆ. ಚಾಟಿ ಚೆಲುವೇಗೌಡರು ಶಾಲೆಗೆ ಹೋಗಿರುವುದಿಲ್ಲ. ಆದರೆ ವಯಸ್ಕರ PW1 during cross examination elicited.
What is the discussion by the trial court on this point?
Chatti Chelvegoda. The
No,
judicial
what is
order.
the discussion by, no, what is the discussion by the trial court and the first appellate court on this evidence? How they analyzed it?
The admission, they're telling admission is there, followed by possession of the original grant certificate.
No,
and-
no. What is the finding of the trial court and the first appellate court on this point? Not your contention. What is the finding of the trial court and first
Finding
appellate
only, I'm
court?
telling, clear. Finding only they are telling, there is an admission on the part of the.
No, where is the finding? No, read the relevant portion of the
Yes.
finding of the trial court and the first
Yes, ma'am.
appellate court.
Yes,
That's
madam.
what I'm asking.
Yes, madam.
Don't read the entire judgment.
No,
Get
madam.
to that specific finding.
Page 56, internal page 22 of the trial court judgment. It is not the case of the plaintiff that father of the defendant number 1 alienated the property in favor of the Channaveeramma and who subsequently sold the same in favor of the defendant number 2. On the other hand, the case of the plaintiff is an together different who claims to state that the said plaintiff acquired the property through the defendant number 2 and his brother, who in turn acquired from one Channaveeramma. So much being case of the such being the case of the burden is heavily upon the plaintiff to show that Channaveeramma had acquired the property from the original grantee. Since I have negated the very assertion of the plaintiff that the original grantee is not the father of the defendant number 1, there is no scope for the plaintiff to place any such right, interest through such Chatti Chelluvegoda, who allegedly lived as on the alleged grantee of the suit said property. On going
No, read that sentence again. No, read that sentence again.
Yes, madam. Since I have negated the very assertion of the plaintiff that the original grantee is not the father of the defendant number 1.
See, all right. Where is this negative? On what basis it is negative? See,
Yes,
the contention is defendant's father has not applied for the grant at all. That is the contention. This contention is based on the ground that his age is wrongly shown and he has not signed the application. He has only put a thumb impression. On this contention, what is the answer?
But they are telling there is no other Chelluvegoda at all. Therefore, they are telling.
What is the answer? What is the answer by the trial court and the first appellate court on this point?
Both have stated that there is no other Chelluvegoda established by the plaintiff. Burden is on them to say that another Chelluvegoda is there. And there is an admission in the proceedings where the name of the defendant number 1 father is shown as Chelluvegoda, Chatti Chelluvegoda by the plaintiffs only. And in an undisputed point of time. And all the revenue courts have held against them. And they have arrived at the conclusion followed by Exhibit P3 possession of the suit property. And so 149 is not, 150 is not sold by the, their prayer for change of khata was rejected.
You can't rely upon the trial court, revenue court judgment. What is the finding of the first appellate court on the contention that the signature could not have been filed, thumb impression could not have been found on the application, and age is shown to be 50. That itself creates a doubt.
They have established that, my lord. They have not plaintiff not established witness.
All right. Even if they have not established, how the trial court would say that this contention is not established with reference to the contention? The specific issue is framed. Issue is rightly framed. My question is, where is the discussion?
Para number, point number 1, appellate court judgment, internal page 7, running page 27. Specifically said, whereas the original grantee Chatti Chelluvegoda at the time of filing the application shown the age as 50 years and put his LTM. The defendant number 2 and his brother late Vishwanatha belongs to them at the time selling the property belongs to survey number 89 bar 1 to 3 as well as 89 bar 5, 7 and 8 shown in the property belongs to plaintiff in the schedule. The defendants have no right over the property. The plaintiff, in order to prove the case of the examined PW1 is deposed according to the plaintiff's etc. etc. How that went while answering, my lord, bottom 10 lines, my lord, and further admitted that Chikkataranhalli Gramadalli ವೈಕುಂಠೇಗೌಡರ ಮಗ ಚಾಟಿ ಚೆಲುವಗೌಡ ಎಂಬ ಹೆಸರಿನ ಮತ್ತೊಬ್ಬ ಬೇರೆ ವ್ಯಕ್ತಿ ಇದ್ದರು ಎಂದು ತೋರಿಸಲು ಮತದಾರರ ಪಟ್ಟಿಯನ್ನು ಹಾಜರು ಮಾಡಿದ್ದೇನೆ ಎಂದರೆ ಹೇಗೆ ಎಂದರೆ ಈ ವ್ಯಕ್ತಿಯು ಬಹಳ ಹಿಂದೆಯೇ ಮರಣ ಹೊಂದಿದ್ದಾರೆ ಮತ್ತು ಈ ಕಾರಣದಿಂದ ಹಾಜರು ಮಾಡಿಲ್ಲ. ನಾನು ಹೇಳುತ್ತಾ ಇರುವ ಮತ್ತೊಬ್ಬ ಚಾಟಿಗೌಡ ನಾನು ನೋಡಿರುವುದಿಲ್ಲ. ನನ್ನ ಊರಾದ ಬರಾಳು ಗ್ರಾಮದಿಂದ ಚಿಕ್ಕತಾರಹಳ್ಳಿ ಗ್ರಾಮಕ್ಕೆ 3 ಕಿಲೋಮೀಟರ್ ದೂರವಾಗಿರುತ್ತದೆ. ಅಂಡ್ ಫರ್ದರ್ ಹಿ ಹ್ಯಾಸ್ ಅಡ್ಮಿಟೆಡ್ ದಟ್ ವೈಕುಂಠೇಗೌಡನ ಮಗ ಚೆಲುವಗಡೆ ಎಂಬ ಹೆಸರಿನ ವ್ಯಕ್ತಿಗಳು ಚಿಕ್ಕತಾರನಹಳ್ಳಿ ಗ್ರಾಮದಲ್ಲಿ 8-10 ಜನರು ಇರಬಹುದು. ನಾನು ಹಾಜರು ಮಾಡುವ ಎಲ್ಲಾ ದಾಖಲೆಗೂ ನಾನು ಈ ದಾಖಲೆ ದಾವೆಗಾಗಿ ಸೃಷ್ಟಿಸಿಕೊಂಡಿದೆ ಎಂದರೆ ಸುಳ್ಳು. 1ನೇ ಪ್ರತಿವಾದಿಗೆ ಸುಮಾರು 35 ವರ್ಷ ವಯಸ್ಸಾಗಿರಬಹುದು. Everything has been narrated, madam. Thereafter.
No. Bhagat, the point urged in para number 2 is very specific. He could not have signed. Sorry, he would have signed. He would not have put a thumb impression. That is one point. Second point is, he was not aged 50. Where is the specific answer to these two contentions?
Yes,
though the issue is framed.
Yes, madam.
Issue is framed. There is no answer.
But in view of the admission.
So based on some other contentions, the trial court might have come to this conclusion. The question is whether there is specific answer to this issue, which is borne out by the pleading. So let it be admitted. Heard. The learned advocate appearing for learned senior counsel. Satamesru. RS. Ravi. RS. We don't mistake manager. RS Ravi, advocate for the appearing for the appellant, and the learned counsel appearing for the respondent. This appeal is admitted to consider the following substantial question of law: whether the trial court and the first appellate court are justified in holding that justified in dismissing the suit and dismissing the appeal. I think what are justified in giving finding on issue number 2 and 3 without referring to the pleading and contention that Chati Chelvegowda who is the father of defendant alva, and without this trial court and the first appellate court are justified.
There is no ground raised in this appeal or no substantial question of framed by them, my lords. It may be seen there.
Just a second. Justified in holding that issue number 2 and 3 are not. Sorry, issue number 2 is not proved by the plaintiff without discussing the contention relating to the age of the applicant. Exhibit Exhibit P2 and the contention relating to the thumb impression appearing in Exhibit P2. P2 and P3, na? P2 and P3. The application seeking production of additional document is to be considered along with the merits. This paper book in 4 weeks. Let me put it. Madam, I don't told music is some case agagate ಏನು ಮಾಡೋದು? Yes. You said you are going to prepare a synopsis. ಆಗಿದೆಯಾ?
Oh my head.
ಸರ್ ನಿಮ್ ನಾಳೆ ತಗೋತೀನಿ. ನಾಳೆ ಪಾರ್ಟ್ ಹಿಂದಿನ ರೋಸ್ಟಿಂಗ್ ಇದೆ ಅದು. ಇದಲ್ವಾ ಯಾವ್ದಂದ್ರೆ ಡಿಸಾನರ್ ಆಫ್ ಚೆಕ್. To get back the situation copies filed earlier to be set up. Any latest judgment on the point?
In fact, latest judgment has not. Not that, in fact, what I like to submit is with regard to the two judgment, which is against to the, not only to me, but also to the statute also. Yakandre, there is no reference. In fact, to the provision 149, simply refers to the section 64 VB and 149. And there is no reference to the
149 of Motor Vehicles Act.
yes, 147.
Just a second. Just a second. In reach agala avuttu, unfortunately, it was not listed. It will be listed on Monday. Howda? Probably they are not prepared. Whatever. Monday. On. 149 of Motor Vehicles Act, you are saying?
149. For the reading of that particular letter pass case.
No, just a second. Brief facts. Accident occurred after cancellation. There is no dispute. There is no dispute.
The question is, and it is the contention of
what you are trying to say is, even after being it is cancelled, they are liable.
yes, before the section 149.
Motor vehicles.
Now, nowhere in the letter pass judgment and two judgment which is against me is authored by Justice S.B. Sinha.
Just a second. Just a second.
1988.
149.
Now it has been rearranged.
No, understood.
Good.
Yes,
88.
Understood. If after the certificate of insurance has been issued under subsection 3 of subsection 146, what you are saying is it is issued under section 146. Certificate kottidara nimge?
No, there is no dispute regarding. They say it has been cancelled. Being effective policy subsection whom the policy has judgment or award liability as is required to be covered by policy under clause B of subsection 1 and B the liability covered by the terms of the policy or under the provisions of section A is obtained against any person by the policy. Then this is the important part of the provision. Notwithstanding that insurer may be entitled to avoid or cancel or may have avoided or cancelled the policy. The insurer shall, subject to the provision of this section, pay to the person entitled.
What do you understand by the expression subject to the provision of this section?
Yes, this provision says where the defense can be taken, what are the defense can be taken, subject to that defense. And fortunately for the claimants, the defense of
dishonor is not available.
Not available. In fact, it says, in fact,
all right. Now, which judgment is against you? Dedappa.
Dedappa and the Ellamma.
What you are trying to say is it's rendered without referring to section 149.
Yes. Therefore, my submission would be that it is a per inquiry.
149 refer agidella.
ಇಲ್ಲ 140 ಇದು particular provision ಆಗಿಲ್ಲ.
149 ಆಗಿದೆ. ಹೆಡ್ ನೋಟ್ ಅಲ್ಲಿ ಕಾಣ್ತಾ ಇದೆ.
Take your lordship to nowhere.
No, para 24.
Reference is being made.
Para 24. We are oblivious of the distinction between the statutory liability of insurance company vis-a-vis third party in the context of section 149.
The same liability arising out of a contract would have to be met if the contract is valid. The contract of insurance has been cancelled. The same question is being, the answer is available in 149. Cancelled and all concerns have been intimated thereabout. We are the opinion, the insurance company will not be liable to such.
No, just a second. Now you have been intimated relating to cancellation.
Yes.
This para 24 is very clear. Para
It
20
says intimated about consent, all the consent, including RTO. The premises under which this judgment was rendered was RTO has been informed. In fact, the one of the judgment.
No, what you started by saying is that 149 is not referred by the judgment by the court.
I'm not saying a 149. Particular portion of the 149 portion regarding the cancellation. If cancellation was referred, then certainly the court, the judgment should have been dealt with that. Discussion should have been done. So discussion regarding that particular portion of the portion.
Is referred.
Portion has
No,
not
you
been referred.
you can't say that it has been rendered without reference to the.
That was referred. Discussion was there. Certainly, the court would have given a finding with regard to the entitlement of the insurer for cancellation. Because in the first case, wherein the Supreme Court has kept open injured cow case, that
No, just a second. What it says is if the contract of insurance has been cancelled and all the consent have been intimated thereabout. Yeah. No, it is your case that all the persons have not been intimated.
even if the law does not say that intimation has to be done.
All right. According to you, the judgment is rendered without properly appreciating 149.
The particular portion, the non-obstructed clause has not been considered at all.
This court can't say that it's for insurance. This court can't say. If there is no reference to section 149, we can say. There is a reference.
Reference, my lord, regarding the cancellation, my lord.
It may not be the way you want it.
No, for that matter, in fact, the judgment rendered by Justice Khanna of the Sanjeev Khanna, who is now the apex court judge.
Don't take the name of the judges. By citing the judgment, don't take the name of the judges.
The forum means. In fact,
Which judgment?
the judgment, Your Honor, Lord, to get it at page number 39, which I have today. This is the proper exposition of the law has been done in this case. Each and every aspect has been considered.
What happened to the judgment?
The judgment was rendered. In fact, there is no appeal preferred in.
So it says paint record.
How? In this case, what has happened is the court was required to adjudicate upon the cover note, not on the
Certificate of
insurance. Cover note, whether the notice issuance, the cover note is valid only for 60 days. Then it requires the insurer to intimate that lapse of that cover note to the
insured.
concerned RTO, not the insured, RTO. Registering one. Whereas no such mandate is being provided with regard to the cancellation of the insurance policy. That is how the judge has differentiated what is between, and ultimately the court has come to a conclusion that it is very illustrative.
No, judgment of Delhi High Court is 2007 judgment.
Yes.
Dedappa judgment is 2008.
Yes.
And moreover, Dedappa judgment.
My lord, why I am relying upon this, though it is a persuasive, I concede it. But the way how it has been interpreted, each and every aspect of section 149 and 147 relevant to the bouncing of the check is being elaborately discussed. That is why I am.
What is the page number 51 last judgment? This court judgment, division bench judgment.
Division bench judgment pay and report. The similar circumstances, situation, this court has come to a conclusion that despite of cancellation,
because of dishonor?
Yes, is at the judgment. That is the last judgment, read at 20 July 2021.
Last time question one last time you didn't say this. You will put it reason main judgment. Read the 11th portion.
Parent number 9. Internal page number 13. Now we may advert to the issue with regard to the liability to pay the amount of compensation from the permission of the answer of the tribunal.
You are for the owner. You are for the owner.
I'm not for the owner.
Pay and recoverable. Pay and recoverable. The Oriental Supra is the Oriental.
It is for case other apartment.
No, check bounce another.
Check bounce. That was the larger bench. The Dedappa case is.
In the recovery there.
I have produced. 28 from 28 to page number 20.
28.
Supreme Court 588. This has been read by this is the larger bench judgment.
This is subsequent to Dedappa. Allah.
No, it is larger bench, 3 judges bench. Dedappa is 2 judges.
Directly on the point ಅದು ಇದು
ಹೌದು ಡೈರೆಕ್ಟ್ ಅದರೊಳಗಡೆ ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ the bench has observed may take your lordship to the page number para number 7. We have therefore this position, despite bar created by 64 VB of the Insurance Act, the appellant and authorized the insurer issue the policy to cover the bus without receiving the premium thereof. By reason of provision section 147 5 and 147 1 of the Motor Vehicle Act, the appellant become liable to the with respect to liability, that policy cover and satisfy the award of the with respect thereof, notwithstanding this entitlement. It has been extracted here, the provision which I read over. Upon which do not express. This is how it has been expressed any opinion to avoid cancel or policy. This portion of the provision of section 149 has not been extracted or discussed in that case. That is my submission.
Why do you refer to Dedappa?
Because Dedappa says that cancellation, once it is cancelled.
No, why do you refer? It is against you. Why are you referring to it?
No, this particular question is not being referred. My Lord put a question to me that there is a reference with regard to 147.
No. Why did you, in the first place, why did you cite Dedappa? That's why I'm asking. You cited or insurance?
No, to make out a case, because all along that Dedappa is being followed. And the third party entitlement has been curtailed.
Followed by who?
But even by this honorable court also.
But the division main judgment is Allah.
That is how this matter came to be heard by several benches.
On what basis the trial court says that reference court tribunal says that insurance company is liable, not liable? Dedappa?
No. Tribunal says pay and recovery.
Pay and recovery idea.
ಇವರು ಅದ್ರ ಮೇಲೆ ಅಪೀಲ್ ಬಂದಿದ್ದಾರೆ.
ಇದು ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ.
ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ.
ಅವ್ರು ಸೈಟ್ ಮಾಡ್ತಾರೆ ಜಜ್ಮೆಂಟ್ ಯಾವುದು? Dedappa.
Dedappa ಮತ್ತೆ ಎಲ್ಲಮ್ಮ. That apart latest ಇದು ಇನ್ಶೂರೆನ್ಸ್ ಇದಕ್ಕೆ ಪ್ರೀಮಿಯಂ ಬಗ್ಗೆ ರೆಗ್ಯುಲೇಷನ್ 4
Ellamma yaradu, which judge?
Ellamma, same,
Ellamma, all right.
author is one and same,
That is 2008.
2008.
It's by two judges.
In fact.
No, just a second. Now read para number 7, which you just now read out.
Indigent court. Indigent court.
We have therefore this position, despite a bar created.
Despite the bar created by section 64 of the Insurance Act, the appellant and authorized insurer issued a policy of insurance to cover the bus without receiving the premium thereof by reason of, very clear manner, by reason of provision 147(5) and 149(1) of Motor Vehicles Act, the appellant became liable to indemnify third parties in respect of the liability that policy covers and to satisfy the award of petition in respect thereof, notwithstanding its entitlement.
So just a second. In Teddappa, this indigent core is not referred.
It is referred. It is referred at the same time. Another judgment.
It is referred. In Teddappa's case, it is referred.
It is referred, man.
And what is the finding?
I am not saying that it is not referred.
How,
Indigent core is referred.
how it is distinguished? Now it is distinguished.
There is no such, in fact, in this case, there is no such distinction. The court has not drawn any distinction between the judgment rendered by the larger bench.
For 64B, what it says, liability commences after receipt of premium, right?
Yes, but at the same time, it says once the check is
For the purpose of this section, in case of risk, premium can be ascertained in advance. The risk may be assumed not earlier than the date on which the premium has been paid in cash or by check to the insurer. For check post, this may be assumed on the date on which the money order book check is posted. Check post ಆದಾಗ ಏನಾಗಿತ್ತು ನಿಮ್ದು ಇದರಲ್ಲಿ ಚೆಕ್ ಇಶ್ಯೂ ಆದಾಗ
ಚೆಕ್ ಇಶ್ಯೂ ಆಗಿ ಆಮೇಲೆ
ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿದೆ
ಆಮೇಲೆ ಬೌನ್ಸ್ ಆಗಿದೆ
ಬೌನ್ಸ್ ಆದ ನಂತರ ಆಕ್ಸಿಡೆಂಟ್
ಆಕ್ಸಿಡೆಂಟ್
ಬೌನ್ಸ್ ಆದ ನಂತರ
ಬೌನ್ಸ್ ಅಂತ ಇದೆ
So the DEPA proceeds on section 64B.
64B, exclusively 64B contract act.
Under section 64B, the risk commences from the date of issuance of check.
Issuance of the check.
And how does it come?
Posting of the check. That does not. This is my submission.
Even if section 64B is referred, they are liable.
Once, if they receive the by check,
then they are liable.
From that point of time,
I think they are trying to rely upon some notification or some.
Yes, madam.
Which one?
That is even the Delhi High Court has referred that in fact there is a discussion regarding that also.
Yes.
I take your lordship to page number, para number 16 of the judgment. The learned counsel.
Page number. Delhi alwa, all right.
Delhi.
All right.
Delhi.
All right. Got it. 44. Learned counsel for the insurance company.
Insurance company has also drawn my.
Gadget notification.
17th October 2002, issued by the Insurance Regulatory Development Authority relevant paragraph of the said note be produced below. The same thing. The commencement in all cases of risk covered by the policies issued by the insurer, the attachment of risk to an insurer will be in consonance with the terms of section 64BB of the Act. And except in the case where the premium has been paid in cash, as in all other cases, insurance shall be only on risk, only after the receipt of premium by the insurer.
All right. Now this is gadget notification amending what?
It is not amended, it is a notification
Notification to what?
regarding 64BB.
64BB is amended.
Commencement of the
64.
but it is contrary to the act itself. It says, the act says that from the date of posting of the check.
All right.
Here the notification says, notification is a different, gives a different version to that. It says
Notification issued under which provision?
IRDA Act. Insurance Regulatory Development Act.
Yes, understood. For dictating judgment. Tuesday. ಅವ್ರು ಮಾಡ್ತಿದ್ದ ಅವ್ರು ಇಲ್ಲ ಅಲ್ಲ ಅವ್ರು ಬಂದಾಗ ಅವ್ರಿಗೊಂದ್ ಸ್ವಲ್ಪ ಕೇಳೋಣ. You be there on Tuesday. You be here on Tuesday.
Tuesday. Monday could not be there. Okay. Monday
I could read your mind.
Thank you, Commissioner.
Yes.
Serial number 52, my lord. Say, Probate matter for final hearing, my lord. Last occasion, your lordship has allowed my application and permitted to use the new PAN number. Your lordship permit, I will make say.
Please say it.
My lord,
yes.
The executors.
You are seeking probate in respect of will, right?
Yes, ma'am.
Yes. Just a second. I will. Whenever I need facts, you can supplement me.
Please, please.
Yes. The petition is filed seeking probate in respect of will alleged to have been executed by
Srimati Amba Subbarao.
Srimati Amba Subbarao, wife of late M.R. Subbarao, who claimed to be the resident of who was said to be the resident of Malleshwaram, Bangalore. Stop. It is the case of the petitioners that the will has been executed by Amba Subbarao, Srimati Amba Subbarao on
5/4/2008.
5/4/2008, and will has been duly attested. Stop. It is the further case of the petitioners that the testator has bequeathed the property in favor of.
She has said, my lord, it has to be used for charity.
Charity ಹೆಸರು ಹಾಕಿದಾರಾ?
ಇಲ್ಲ ಇಲ್ಲ ಅವರು in different amount ನ different purpose ಗೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ, for you to use the Brahmin community.
Then petitioners are only executors, right?
Yes,
petitioners are only
they are only executors.
Yes. The petitioner has ಏನಾಯ್ತು ಮೇಡಮ್? The petitioner has executed the will for distributing her assets in favor of certain identified charities specified in the will. Stop. For certain charitable purposes specified in the will. For certain charitable purposes specified in the will. The present petitioners are the executors under the will. Stop. Relationship with your
Yes, sir. All the executors are the children of sisters of the deceased.
It is further stated that the deceased testator was issueless and petitioners are the children of sister of the testator. Stop. This court had issued the, this court has directed the citation to be published in the daily newspaper having circulation in state of Karnataka. Stop. The properties are located in Karnataka, na?
Yes, ma'am.
Mobile ಎರಡು ಇದೆಯಾ? Mobile
and immobile, both are there.
The properties specified in the will, which are described in the petition, are the properties located within the state of Karnataka. Thus, citation was ordered to be published in the newspaper having a publication in state of Karnataka. The citation was duly published. Thereafter the evidence of the attesting witness, attesting evidence of the two attesting witnesses is recorded by this court. Stop. Next paragraph. Learned counsel for the petitioner would submit that there is no impediment to grant the probate in respect of in respect of the will of date Sri
Srimati Amba Subbarao.
Stop. This court has perused the petition, and this court has also perused the will produced by the petitioners. This court has also perused the evidence recorded by the evidence adduced by the attesting witnesses. Stop. The attesting witnesses to this will have identified the signature of the testator, have also identified their own signature, and they have also stated about the attestation of execution of will by testator. Accordingly, this court finds there is no impediment to allow the petition. Stop. There is no objection. There is no objection by anyone to allow the petition, despite citation being published. Under the circumstances, the petition is allowed, and probate is granted in favor of the petitioners in respect of will and testament dated executed by late Srimati Amba Subbarao. Stop. Rest of the conditions will follow.
Yes.
And only thing is, it is also made clear that the executors are not the beneficiaries under the will. It is stated in the will that the executors have to apply the properties covered under the will for the benefit of charities specified in the will. Under the circumstances, the petitioners shall have to apply for PAN number as provided under section 168 of Income Tax Act, and the concerned authority shall accept the application filed by the petitioners for issuance of PAN number in respect of assets of PAN number in favor of the petitioners in respect of assessment of tax payable by
late Srimati
Amba Subbarao. Stop.
And my lord, they may be permitted to deduct the expenditure to be incurred for all these things while
It is there in the will. It is there in the will.
My lord, that is there, but not in proper wordings. It says that, my lord, it should be in every line in the para. They say that it has to be distributed. There is no specific line as such.
Where do you get that? Even a remote inference.
For charity, it is not, my lord, is not true. No, my lord, there is.
No, if it is not there, then it is not possible.
I would like to mention here that the money so really should not be used for the nominees which have been sufficiently paid to post office.
Court can't go beyond the wish of the testator.
Yes, sir. I leave it there itself now.
All right. Hello. Or Learned advocate Sri K.V. Arvind, appearing for the government, has submitted that the petitioners have to be assessed in terms of section 168 of Income Tax Act. Said submission is placed on record.
Much of it.
You have to execute the administration bond, right?
Yes, my lord, that we have to execute in the office.
Yes. All those conditions will incorporate.
Yes, my lord, please.
Inventory and
yes,
Accounts. Yes.
It has to be introduced later.
Yes.
Please. Fine.